Anna, has everyone joined the main hearing room from the breakout rooms?
Yes, they appear to have.
Good. Then I'm pleased to welcome you all to this hearing. Good morning or good afternoon, depending on where you are. Let me check who's online. We of course have the tribunal, Ms. Levine, Mr. Shore, and with me in the same room, the assistant of the tribunal, Dr. Langer. Then we have the tribunal secretary from ICSID and people who assist her, Ms. Holloway. Then we have the claimants. I see them in a conference room. Do I have everyone who's on the participants list? And I actually also see Mr. Cottrell, who must be in New York when the others are, no, they're all of them are in New York, but you're in another place apparently. Let me check with Mr. Rubenstein whether you have everyone online for the claimants.
Yes, Madam President, we're all here.
Good, excellent. Let me then turn to the respondent. Do I see Ms. Zeman on the screen? Yes.
Yes.
You're the one in the middle.
Hello. Yes, in the yellow.
And you have with you on the screen Ms. Squires and Ms. Dossman, is that right?
That's right. And in the room, we have the other members of our litigation team, Mr. Koziel, Ms. Harris, and our excellent paralegals, Ms. Bacalar and Ms. Maza Panero.
Excellent. Is Mr. Little there as well?
He is joining us virtually.
Yeah.
And he is here, yes.
Is here, yeah.
Yes.
Fine. And then we have among the representatives of Alberta, do I have, is everyone present? Maybe Ms. Zeman, you can let us know.
Yes, we have everyone but one person who's logged in so far. We expect her to join, that's Ms. Spears. But there's no need to wait to proceed. Fine,
excellent. Good, and then let me see, we also have the non-disputing party representatives for the US. Am I correct that we have Mr. Big?
Yes, good morning. This is David Biggie, and we also have Julia Brower.
Excellent, thank you. And for Mexico, I see Ms. Hernandez, is that right? And
yes, yeah, I'm here joined by Mr. Alan Bonfigio and Alejandro Rebollo.
Fine, so all three of you who are on the participant list are present. Excellent, and we also have the court report of Ms. Larson, whose participation is very much appreciated. We will, this hearing is devoted to jurisdictional objection. We will follow the rules set in procedural order number 3 and in part also number 1, as well as the schedule that is annexed to procedural order number 3, but a revised version was sent yesterday with the addition of the oral presentation of Mexico. there's just one question that arose a few minutes before we start. We received the respondents' PowerPoint presentation, and we assume that we can, that ICSID can share this with the non-disputing parties. Is there any issue with that? Because reading PO2, it was not exactly clear where it would, under which rubric it would fall. Any objection from the respondent?
No objection here.
Any objection from the claimant?
No objection, Madam President.
Good, fine. So Anna, you can forward the presentation, and you can of course do the same when we receive the claimant's presentation. So the schedule for today is to essentially hear the parties' oral argument, in part in answer to the questions that the tribunal had sent you on 16 April, and for the rest, we're happy to hear your arguments in more generally. And then we will, at the end of today, if we have additional questions, we will put them to you so that you can answer them tomorrow. And then tomorrow, in addition to the answers to the questions, there will be some brief rebuttal presentations. Is there any question or comment that the parties would like to raise before I give the floor to Canada for its oral argument? Let me first turn, since we're on jurisdiction, I would first give the floor to the respondent. Ms. Zeman?
We have nothing further to raise at this point. Thank you.
Thank you. Anything on the claimant side, Mr. Rubinstein?
No, Madam President, we do not have any comments at this point.
Good. Then we're ready to listen, and I'll give the floor to you, Ms. Zeman.
Thank you. I'll begin today with a few words of introduction before explaining how we organized our opening presentation. As the tribunal knows well, investor-state arbitration is a creature of consent. Canada's consent to arbitrate an investor's claim under CUSMA Annex 14C and NAFTA Chapter 11 is subject to a number of conditions. An investment claim under these treaties necessarily involves a particular investor, a particular investment, at least one allegation of treaty breach, and an allegation of loss as a result, all at a particular point in time. If the claim, understood as comprising those components, has been submitted to arbitration in accordance with all of the requirements of the treaties, then Canada has consented to arbitrate it. And it is that perfected consent that grounds the jurisdiction of the tribunal constituted to hear it. An investment tribunal constituted under these treaties does not have the authority of courts of inherent jurisdiction and cannot take jurisdiction solely on equitable grounds. The claimant here has not established that the claim that it filed on a particular date, October 14th, 2022, which makes particular allegations about itself as an investor, about particular investments, and about treaty violations and resulting losses, meets the conditions of Canada's consent to arbitrate. As a result, this tribunal does not have jurisdiction. The claimant has attempted to avoid this inevitable conclusion in a few ways. It has blurred the lines between distinct claims. It has misconstrued the factual background, blaming Canada for its own actions. It has responded to legal arguments it wishes that Canada made, rather than the treaty-based arguments Canada has actually made. And it continues to ask the tribunal to create jurisdiction where it does not otherwise exist by resorting to principles of equity. When the tribunal assesses the record and interprets the terms of the treaties as they are, it will find that none of the claimant's attempts can be sustained. The claim must be dismissed. To that end, the tribunal has 6 questions to answer. Now, we'll address the details of each of these over the course of the morning or afternoon. But for now, I want to focus on the consequences of the tribunal's ultimate decisions with respect to each for the claimant's claim. The first question is whether the claimant holds a legacy investment under CUSMA Annex 14C. Canada's consent to arbitrate claims under the annex is limited to legacy investments, which, among other things, must have been held by the claimant when CUSMA entered into force on July 1st, 2020. The claimant sold all of its investments in Canada on March 15th, 2019. As a result, the answer to this first question is no. And if the tribunal agrees, the consequence is dismissal of the entire claim. The tribunal need not proceed further. If the tribunal answers yes, then it must proceed to evaluate whether the claimant's claim also meets the jurisdictional requirements of NAFTA. And we've made organizational decisions about the ordering of the remaining questions, but there's no particular magic to it. The second question is as whether the claimant submitted valid waivers consistent with NAFTA Article 1121. The claimant has only submitted waivers that accompanied a different notice of arbitration, which were later withdrawn. Moreover, the claimant has not confirmed with evidence whether the individuals who signed those waivers had the authority to bind the companies on October 14th, 2022. As a result, the answer to the second question is also no. If the tribunal agrees, the consequence is dismissal of the entire claim. If the tribunal answers yes, then it must proceed to the third question. Is the claim timely under NAFTA Articles 1116(2) and 1117(2)? The measures the claimant challenges date back to 2015 and 2016. The claimant filed its claim more than 6 years later. As these treaty provisions do not permit suspension or prolongation of the 3-year limitation period, the answer to the third question is also no. If the tribunal agrees, the consequence is dismissal of the entire claim. And again, the tribunal need not proceed further. Now, the treaty requirements reflected in questions 1 through 3 are cumulative. The claimant must establish it meets all of them. If the tribunal answers no to any of them, the claim cannot proceed. In order to move on to the remaining 3 questions, and potentially to hearing the claim, the tribunal must answer all 3 with a yes. And if that is the case, it must then proceed to the next 3 jurisdictional issues. The claimant has brought its claim both on its own behalf under NAFTA Article 1116 and on behalf of Prairie under NAFTA Article 1117. There are 3 additional independent jurisdictional hurdles the claimant must overcome. The first of these, and the 4th question before the tribunal, is whether the claimant has made a prima facie damages claim as required by NAFTA Article 1116. Since the claimant has only asserted loss that belongs directly to Prairie, which is not recoverable under Article 1116, the answer to this question is no. If the tribunal agrees, the consequence is dismissal of the Article 1116 claim. And that will leave the claimant only with its Article 1117 claim. But the 5th and 6th questions before the tribunal relate to this part. The 5th is whether Prairie has acted consistently with the waiver that it submitted in the Westmoreland Mining Holdings versus Canada, or WMH, arbitration. In that proceeding, Prairie waived its right to initiate or continue proceedings seeking damages with respect to the measures at issue in that case. Initiating such proceeding is precisely what the claimant has done on Prairie's behalf in this claim. As a result, the answer to this question is no. If the tribunal agrees, the consequence is dismissal of the Article 1117 claim. The 6th and final question is whether the claimant owned or controlled Prairie when it submitted its claim to arbitration as Article 1117 requires. The claimant sold its interest in Prairie more than 3 years prior to filing its claim. The answer here is thus no. If the tribunal agrees, the consequence is dismissal of the Article 1117 claim. And if the tribunal has also answered no to the Article 1116 claim, the consequence is dismissal of the entire claim. And that is the case, even if the tribunal has answered yes to questions 1 through 3. Now, there's one question missing from this decision tree, and that's whether the federal fuel charge relates to the claimant or its investment under NAFTA Article 1101. And that's because the claimant has withdrawn its allegations with respect to that measure, and Canada has accepted that withdrawal. The remainder of Canada's opening statement is organized along the lines of this decision tree. First, I'll spend a bit of time addressing background facts. Then we will address each of the legal questions before the tribunal in turn. I will first address the legacy investment issue. Ms. Squires will address the validity of the waivers filed. Ms. Dossman will then address the limitation period. Ms. Harris will address prima facie damages. Ms. Squires will return to address Prairie's waiver in the WMH proceeding. And Mr. Koziel will both address ownership and control of Prairie and conclude Canada's opening statement. We'll address the 5 questions the tribunal put to the parties on April 16th throughout our statement and have attempted to note expressly where we are doing so. Beginning with the factual background. I've organized the facts into 3 chapters. Chapter 1 covers the claimant's acquisition and sale of interests in Canada. Chapter 2 covers the measures the claimant has put at issue in this case and summarizes its claim. Chapter 3 covers certain historical facts relating to separate prior claims of the claimant and of the arm's length purchaser of its interests in Canada, Westmoreland Mining Holdings. We'll build all the key events across these chapters into the same timeline for the tribunal to take away. But I'd also refer the tribunal back to Canada's Memorial on Jurisdiction, starting at page 33, for a summary of key dates for the jurisdictional phase in a table form. Chapter 1, the claimant. The claimant was incorporated in Delaware in 1910. It was a publicly traded company that operated coal mines throughout the United States. In 2014, it purchased a number of interests in Canada from a company called Sherritt International. Among those assets was Prairie Mines and Royalty ULC, or Prairie for short, an Alberta enterprise that owns thermal coal mines and sold coal to power plants. WCC held its interests in Prairie before it sold them in the manner set out on slide 6. As you can see, it was a limited partner in the ultimate partnership that held the interests in Prairie. On October 9th, 2018, the claimant and 36 of its US affiliates filed voluntary petitions for bankruptcy in Texas, citing a number of events that led them to that point. Those included the rising cost of capital, competition from inexpensive natural gas, a lack of growth in energy demand, and increased regulation. Those reasons can be found in Exhibit R57 at pages 19 through 24. The claimant explained to the US Bankruptcy Court that its bankruptcy plan contemplated the sale and transfer of substantially all of the WCC assets and equity interests, efficient distributions to its creditors, and a subsequent wind down of its business upon completion of the distributions under the plan. And that is what the claimant did. On March 15th, 2019, the sale transaction was executed, and WCC transferred its interest in Prairie to a new company created on behalf of its first lien lenders, Westmoreland Mining Holdings, LLC, or as we'll refer to it throughout today, WMH. You'll hear more about the legal consequences of this fact for the claimant's claim when I discuss what a legacy investment is, and when Mr. Koziel addresses the ownership or control question under NAFTA Article 1117. There is no dispute about this date or the fact that the interests in Prairie were sold. And it's important to understand that this sale was negotiated at arm's length. This both provides general context for the relationship between WCC and WMH and is relevant to the claimant's erroneous time bar theories. In the order confirming the claimant's bankruptcy plan, the U.S. bankruptcy judge presiding over the case held the sale transaction was proposed and entered into in good faith and from arm's length bargaining positions. The WMH tribunal reached the same conclusion in its award in that case, finding that the first tier lien holders were able to purchase certain of WCC's assets, including the Canadian enterprises, in an arm's length transaction. It further concluded that WCC's bankruptcy was not a corporate restructuring pursuant to which WMH emerged from WCC's ashes. Both of those quotes are from paragraph 230 of RLA 1. Now this brings a close to chapter 1. The claimant purchased interests in Prairie in 2014 and sold them in an arm's length transaction in 2019. Chapter 2 will situate the measures the claimant has challenged in this claim on the same timeline. On November 22nd, 2015, Alberta announced its 2015 Climate Leadership Plan. The plan included a policy announcement to phase out emissions from coal-fired electricity generation by 2030, an update to Alberta's industrial emitters carbon pricing regulation, and the introduction of a new consumer fuel levy that would apply to non-industrial emitters. On June 13th, 2016, Alberta enacted the Climate Leadership Act, which imposed the new carbon levy on consumer fuels. On November 24th, 2016, Alberta announced that it had concluded off-coal agreements that allocated transition payments to 3 power plant owners with generating units scheduled to operate beyond 2030. Finally, on January 1st, 2020, Part 1 of the Federal Greenhouse Gas Pollution Pricing Act, which established the federal fuel charge, a regulatory charge applied to the producers, distributors, and importers of various types of carbon-based fuel, began to apply in Alberta. As noted earlier, the claimant has withdrawn its allegation of breach with respect to this measure. In its notice of arbitration, filed pursuant to CUSMA Annex 14C and NAFTA Chapter 11 on October 14th, 2022, the claimant alleges that these measures have violated NAFTA Articles 1102, National Treatment, 1105, Minimum Standard of Treatment, and 1110, Expropriation. Its alleged investments are Prairie, interests in Prairie, and certain of Prairie's assets. It has also asserted that a prior NAFTA claim constitutes a separate investment. Despite bringing its claim under both NAFTA Article 1116 on its own behalf and under Article 1117 on behalf of Prairie, it alleges damages representing only Prairie's lost revenues from coal sales and Prairie's accelerated reclamation costs. It has not yet quantified its alleged damages. The claimant filed with its 2022 NOA waivers for itself and for Prairie that were both dated from 2018. Ms. Squires will address the legal consequence of this fact a bit later this morning. Now, in its question number 3, the tribunal has asked the parties about the scope and impact of the claimant's withdrawal of its claim with respect to the federal fuel charge, in particular in respect of the expropriation claim under NAFTA Article 1110. Now, the claimant has made 2 allegations of violation of NAFTA Article 1110. The first is based on Alberta's, and I quote from paragraph 92 of the claimant's NOA, payments to coal-fired electricity units combined with federal and provincial carbon taxes, end quote. The second is based on Alberta's, quote, introduction of a regulatory scheme to phase out coal by 2030, along with its punishing levies on coal, That's at paragraph 91. Canada understands that by withdrawing its claim with respect to the federal fuel charge, the claimant has withdrawn at least its first allegation of violation of Article 1110. This is the only alleged violation that involves the federal fuel charge. Now, I expect we may have a bit more to say on this one tomorrow once we hear from the claimant. But to the tribunal's question 4, to the extent there is a residual expropriation claim based only on 2015 and 2016 Alberta measures, Ms. Squires and Ms. Dossman will explain that Canada's positions with respect to waiver and time bar remain unchanged. There remains no waiver filed with the claim, and such an expropriation allegation is time barred. And that brings us to chapter 3, prior claims. And in this chapter, we'll get into part of the tribunal's question number 2, which asks whether the 2018, 2019, and 2022 claims are identical, as the claimant argues, or are they separate and distinct, as the respondent contends, and what is the effect of such a determination? And we'll look at the parameters of the prior claims and how they compare to the claim before the tribunal in this chapter. But as a first observation, both the party submissions and the tribunal's question illustrate that the term claim can mean different things in different contexts, and that can be useful. For example, claim can refer to a factual allegation or to a particular allegation of treaty violation or loss. The claimant largely refers to claim in this way. But claim can also refer to the broader package of allegations that a particular investor submits to arbitration in a notice of arbitration at a particular point in time. This is what establishes whether consent to arbitrate under the treaties has been perfected and whether a tribunal has jurisdiction to consider the merits of the claim. Both CUSMA Annex 14C and NAFTA Article 1122 establish that there are 2 parts to perfected consent, and thus to the creation of an arbitration agreement. First, the state party consents to the submission of a claim to arbitration in accordance with the procedures of the treaties. Second, that consent, coupled with the submission of a claim to arbitration in accordance with those same procedures, creates an arbitration agreement. When is a claim submitted to arbitration? NAFTA Article 1137(1) tells us when the NOA is received by the disputing state party. It is thus the text of the treaties on the one hand, and the content of the NOA, which represents the claim submitted to arbitration, on the other, that provide a tribunal with the information it needs to determine whether an agreement to arbitrate has been reached and whether, by extension, it has jurisdiction. This is how Canada uses the term claim when it says the claims are separate and distinct. Each NOA represents a claim that was submitted to arbitration and thus a potential agreement to arbitrate. And this is how Canada invites the tribunal to look at the prior claims and their relevance to its task here, determining whether WCC's 2022 NOA establishes an agreement to arbitrate between Canada and WCC. Now, we've attempted to illustrate, perhaps crudely, the components of the arbitration agreement with this puzzle. All of the pieces laid out in an NOA that submits the claim to arbitration at a particular time are necessary for the tribunal to find an arbitration agreement. Allegations of treaty breach and loss that comply with the treaties are only 2 components of what is necessary to ground a tribunal's jurisdiction. When the tribunal is assessing whether it has jurisdiction, it must come back to the full set of conditions of consent. Similarity in allegations of breach and loss between claims that were separately submitted to arbitration do not create the arbitration agreement. And as we'll see over the next few minutes, no prior agreement to arbitrate has crystallized between Canada and WCC or between Canada and WMH. With that context, we'll return to 2018. November 19th, 2018 in particular, when WCC submitted its first NAFTA claim to arbitration. This was the first potential agreement to arbitrate. In that NOA, the claimant brought its claim under NAFTA Chapter 11 only. It brought it under Article 1116 on its own behalf and Article 1117 on behalf of Prairie. It alleged violations of only two of the measures we discussed in Chapter 2, Alberta's 2015 decision to phase out emissions from coal-fired electricity generation, and its 2016 allocation of transition payments to power plant owners. It alleged that these measures violated NAFTA Articles 1102 and 1105, and alleged investments in Prairie, interest in Prairie, and certain of Prairie's assets. It alleged damages exceeding $470 million that represented Prairie's lost revenues from coal sales and accelerated reclamation costs. You can see the differences between the 2018 NOA and the claim before the tribunal on slide 23. The 2022 NOA challenges measures that the 2018 NOA did not, and alleges a violation of Article 1110, which the 2018 NOA did not. The 2022 NOA further asserts an investment in what appears to be the 2018 NAFTA claim. It has not quantified damages, though claims the same heads of damage as the 2018 claim. Now, the reason we're all here today can be traced back to the next event in Chapter 3. The claimant's attempt to sell its 2018 NAFTA claim. You'll note that the claim was filed after the claimant filed its bankruptcy petition, in contrast to the claimant's recent statement that it had lodged the claim prior to the bankruptcy. It was the claimant's choice to try to sell the 2018 NOA in its bankruptcy process. The claimant was a sophisticated business entity. It was publicly traded, and its own bankruptcy proceeding involved 36 of its US affiliates. As the claimant explained in its response on jurisdiction, the company handled its NAFTA claim with comprehensive deliberation, involving input from outside consultants, external bankruptcy counsel, external NAFTA counsel, and WCC's board of directors. Canada was not a party to WCC's bankruptcy proceeding and learned of the existence of WMH and the attempted sale of the NAFTA claim for the first time on receipt of the attempted amendment. So what exactly did WCC try to sell to WMH? The Stalking Horse Purchase Agreement, negotiated between the first lien lenders on the one hand and the claimant and its affiliates on the other, defined the NAFTA claim for sale as that certain claim filed with the Office of the Deputy Attorney General of Canada on November 19th, 2018. In other words, the 2018 NOA that had already been submitted to arbitration. You may also note that the definition includes a parenthetical, as such claim may be amended. Now, that may be a general way of preserving some flexibility with respect to a claim, but it may also suggest that WCC and WMH had already been planning an amendment to the 2018 NOA to substitute the new purchaser as the claimant. With the sale transaction completed on March 15th, the transactor's next step was to notify Canada of the sale and their proposal for reflecting its result in the 2018 NOA. On May 13th, 2019, Canada received the attempted amendment. Now, there's been much debate between the parties on the nature of the proposed amendment. Was it substitution or was it addition? Why are we having this debate? Well, it's because the claimant has come up with a litigation strategy to blame Canada for its own decisions. It is trying to rewrite what happened, saying now that they were not proposing substitution at the time and that Canada forced it to withdraw its claim. it attempts to paint a picture of bad faith behavior that is not supported by the record in its bid to establish this tribunal's jurisdiction. The tribunal will no doubt review the contemporaneous evidence in the documents contained in exhibits R80, C55, and R81 through R84 closely to form its own views. To assist the tribunal with its task, I'll highlight a few parts of this correspondence this morning. Canada's view is that the contemporaneous evidence demonstrates that everyone understood at the time that this was an attempted substitution. At minimum, it is clear from the documents that that was Canada's understanding at the time. And if that was a misunderstanding, neither the claimant nor WMH attempted to correct it. The documents instead confirm that the claimant's post hoc argumentation before this tribunal cannot be sustained. In particular, the revised NOA, which is at exhibit C55, indicated that there was a proposed substitution and not that WCC intended to participate as a claimant alongside WMH as the claimant now argues. For example, the front page of the document identifies only WMH as the claimant investor. If WCC were truly intending to participate, the clearest way to identify that would have been to include both companies as the claimant's investors. Now, the claimant also argues in its rejoinder that the case caption did not mention Prairie, which Canada acknowledges was and remained claimant. This is incorrect. Canada has never acknowledged Prairie as a claimant because Prairie cannot be a claimant under NAFTA Chapter 11. It is a Canadian enterprise, and NAFTA Article 1117(4) is clear that it cannot bring a claim against Canada. Now, the text of the document also suggested that WCC was looking to amend itself out of its claim. The claimant points to the inclusion of WCC in the first paragraph as support for its argument that WCC intended to participate as a claimant. But it's not clear how WMH could have amended WCC's NOA without some reference to WCC. We also see that WMH is given the short form Westmoreland for the document. And in the next paragraph, Westmoreland, just defined as WMH, elects the UNCT rules as the claimant under NAFTA Article 1120, subparagraph 1. The procedural requirements section of the document identified WCC as the initial disputing investor and explained that WCC sold Prairie, other assets, and the instant NAFTA claim to WMH. It stated that WMH was the owner of the assets, interests, rights, and claims of the initial disputing investor, WCC. And it introduced WMH as the disputing investor. Read in context, initial disputing investor, who sold all its rights and interests to the disputing investor, does not leave the impression that WCC would continue to pursue the claim alongside the new owner of all its rights. On July 2nd, 2019, Canada responded to the attempted amendment, articulating its view that the proposed amendment was not permitted by Article 20 of the UNCT rules. This is Exhibit R81. In particular, Canada explained that under Article 20, if an amendment would cause the claim to fall outside the jurisdiction of the arbitral tribunal, it is a new claim, and that the substitution of a new claimant is such an amendment. As a result, Canada concluded that WMH could not become the disputing investor in a claim that was submitted to arbitration by WCC. Instead, WMH needed to submit its own claim and meet the requirements of Canada's offer to arbitrate. Those included the delivery of a notice of intent at least 90 days before submitting a claim to arbitration. But because it seemed evident that WCC and WMH intended for WMH to replace WCC as the disputing investor, Canada made an offer that would save WMH time. Canada was prepared to accept the May 13th amended NOA as WMH's notice of intent, which meant that WMH could then submit its own claim to arbitration once 90 days had passed from May 13th, rather than from some date after the date of this letter, July 2nd. In exchange for the time savings, and consistent with Canada's understanding of what the requesters were attempting to do, Canada proposed that WCC withdraw its claim. What Canada was not proposing was that it would only accept a substitution if WCC withdrew its claim. Canada did not accept that substitution was possible. Canada was also not insisting that WCC withdraw its claim or no claim could proceed at all. Indeed, it's hard to understand how a proposal conveyed in a single letter could be characterized at all as insistence. But importantly, the letter and the proposal were focused on the issues raised by the attempted amendment and the appropriate mechanism for changing a claimant in a NAFTA claim, as WCC and WMH were looking to do. Canada made it clear that it was making its proposal without prejudice to its ability to raise any jurisdictional or admissibility objections with respect to the original NOA, that is, the one submitted to arbitration by WCC on November 19th, 2018, or to any new claim. For example, a claim that might be submitted to arbitration by WMH. Canada did not suggest in this letter that it would not raise any jurisdictional objections with respect to a WMH claim, nor did it state that it would accept the jurisdiction of a tribunal constituted to hear either the original WCC claim or a new WMH claim. On July 3rd, 2019, just one day following Canada's proposal, the requesters wrote to Canada at Exhibit R82. Notably, the letter acknowledged Canada's view that the attempted amendment was filed by WMH and not by WCC, acknowledged Canada's understanding of the proposal as a substitution. It expressed disagreement with Canada's analysis of Article 20, and despite this agreement, chose to benefit from the time savings for WMH's claim and to withdraw WCC's claim. Equally of interest in this response is what it did not do. It did not state anywhere that WCC had intended to continue on as a claimant alongside WMH, and it did not convey its purported understanding that Canada would not raise jurisdictional objections. The claimant's witness, Mr. Stein, expresses shock that after this agreement was reached, Canada raised jurisdictional objections with respect to WMH's 2019 NOA. Canada's letter does not provide a reasonable basis for any conclusion that Canada had waived jurisdictional objections. Now, it's worth noting that Canada was not communicating directly with Mr. Stein or with anyone else at WCC or at WMH. There was an intermediary, claimant's counsel. To the extent that the letter was being interpreted, it was not Canada doing the interpreting. Nor was there any requirement to accept Canada's proposal. It was an offer, which WCC and WMH were free to reject, counteroffer, or accept. The choice to accept was entirely theirs, guided by the sophisticated and comprehensive advice they expressed they were receiving. Now, I want to pause here to note that regardless of whether the attempted amendment proposed a substitution or an addition, what happened next was neither. It was the withdrawal of one NAFTA claim by one investor and the submission of a new NAFTA claim to arbitration by another, each representing a distinct potential agreement to arbitrate. On July 23rd, 2019, WCC withdrew its 2018 claim, along with the waivers that were filed with it. That put an end to the first potential agreement to arbitrate. Now we're going to switch the timeline scale a bit here to address the final few steps. WMH then submitted its claim to arbitration only under NAFTA Chapter 11 on August 12, 2019, 90 days after May 13th. This was the second potential agreement to arbitrate. The NOA asserted claims under NAFTA Articles 1116 and 1117, and was accompanied by valid waivers for WMH and Prairie. It alleged violations of Articles 1102 and 1105, arising out of the same two measures that WCC had raised in its 2018 NOA. It did not allege a violation of the expropriation obligation and did not claim to have an investment in WCC's 2018 NAFTA claim, despite having purchased it in the US bankruptcy transaction. On January 31st, 2022, the WMH tribunal dismissed WMH's claim on the basis that it did not hold its investment in Prairie at the time of the alleged breach as NAFTA required. It further found that WMH could not pursue the claim anyway because it was not the legal successor to WCC coming out of WCC's bankruptcy process. Disappointed with that result, on October 14th, 2022, WCC filed the new claim before this tribunal. This is the third potential agreement to arbitrate. Now, returning to the tribunal's question number 2, we've summarized on slide 39 the many ways in which the claimant has not established that the 2018, 2019, and 2022 claims are the same. And we won't go through all of these, but their beginnings and endings illustrate the differences. The 2018 arbitration began when Canada received WCC's 2018 NOA and ended when WCC withdrew it. No agreement to arbitrate crystallized between Canada and WCC. The 2019 arbitration began when Canada received WMH's 2019 NOA and ended when the WMH tribunal determined that there was no agreement to arbitrate between Canada and WMH because the claim did not meet the conditions of Canada's consent to arbitrate. The 2022 arbitration began when Canada received WCC's 2022 NOA without waivers. The existence of an agreement to arbitrate between Canada and WCC is the very question pending before this tribunal. Despite similarity in allegations of breach and loss, these claims represent 3 distinct potential agreements to arbitrate. Now, the claimant's allegations in this regard relate primarily to their time bar arguments. And so Ms. Dosman will return to the effect part of the tribunal's question 2 when she addresses the limitation period. That brings a close to chapter 3 and to our survey of background facts. We'll move next to the first legal question the tribunal has to answer. Does the claimant hold a legacy investment under CUSMA Annex 14C? As I explained earlier, the answer to this question is no. CUSMA Annex 14C requires a claimant to hold the investment with respect to which it brings its claim when CUSMA entered into force. The claimant did not. As a result, Canada has not consented to arbitrate this claim, and the tribunal does not have jurisdiction. The claimant has attempted to avoid this conclusion by conflating distinct issues and raising a number of straw man arguments. For example, in its rejoinder, the claimant has posited that the main area of disagreement between the parties is whether the legacy investment protection extends to claims that materialized prior to the implementation of CUSMA. But the question of what government conduct is captured by Annex 14C is not disputed before this tribunal. Instead, the issue is when does a claimant need to hold an investment for it to qualify as a legacy investment? We'll try to untangle some of these issues this morning as we move through 3 parts of argument. First, we'll take a close look at the text of CUSMA Annex 14C and the express requirements of Canada's consent to arbitrate. This part will address the tribunal's question number 1. Second, we'll examine how the claimant has failed to establish that it meets these express requirements. Finally, we'll address why the claimant's efforts to establish jurisdiction based on equitable principles must be rejected. Turning to the first. On July 1st, 2020, CUSMA superseded NAFTA. This is the only free trade agreement in force between Canada, the United States, and Mexico. CUSMA Chapter 14, the investment chapter, does not have a trilateral ISDS mechanism. In fact, Canada has not consented to arbitrate any investor state claims that arise under CUSMA Chapter 14. Given that NAFTA was terminated at this time, the treaty parties' consent to arbitrate claims under NAFTA Chapter 11 was also terminated. As the United States has recently explained, the default outcome after the NAFTA's termination was that there would be no recourse to arbitration for alleged breaches of the NAFTA. You can find that at R156, paragraph 52. There is one limited and narrowly circumscribed exception contained in Annex 14C. Annex 14C features 6 paragraphs. It sets out the treaty parties' limited consent to arbitrate certain claims arising under NAFTA Chapter 11 for a period of 3 years following its termination. The focus of the annex is consent to arbitrate claims. Its title is Legacy Investment Claims and Pending Claims. Paragraph 1 of the annex establishes that each party consents, with respect to a legacy investment, to the submission of a claim to arbitration in accordance with Section B of Chapter 11 of NAFTA and this annex that alleges a breach of Section A of NAFTA Chapter 11. At the outset, in paragraph 1, we see a few limitations on this consent to arbitrate. First, the consent is exclusively for a claim with respect to a legacy investment. Second, the submission of the claim to arbitration must accord with the requirements of the dispute settlement section of NAFTA Chapter 11 and with the requirements of CUSMA Annex 14C. And third, the consent is with respect to a claim that alleges breaches of the substantive protections of NAFTA Chapter 11. Paragraph 6 of the annex sets out the definitions applicable to the annex. Subparagraph A defines the term most relevant to the tribunal's task here, legacy investment. For the purposes of the annex and the CUSMA parties' consent to arbitrate claims under the annex, legacy investment means an investment of an investor of another party in the territory of the party, established or acquired while NAFTA was in force, and in existence on the date of entry into force of this agreement. Thus, a legacy investment is an investment of an investor of another party that meets the 3 subsequent requirements. While CUSMA Chapter 14 contains its own definitions of investment and investor of a party, which would otherwise apply to the definition of legacy investment, subparagraph B indicates that the terms investment and investor have the meanings accorded to those terms in NAFTA for the purposes of the annex. So we go to the text of NAFTA to help inform our understanding of the term legacy investment in the annex. NAFTA Article 1139, the definitions provision, defines both terms. Investment, for the purposes of NAFTA's investment chapter, is a closed definition that sets out certain of the parameters of what qualifies for investment protection under the chapter. Now, apologies, the definition is too long to fit readably on one slide, but suffice it to say that there are 8 categories of investment, and an alleged interest must fall within one of them and not fall into one of the exceptions. NAFTA Article 1139 also defines investor of a party, which for purposes of Annex 14C is important for understanding who must have made and held the relevant investment at the specified times. According to NAFTA, an investor of a party means, in relevant part, an enterprise of such party that seeks to make, is making, or has made an investment. So, coming back to the definition of legacy investment, with the NAFTA definitions in mind, we see that a legacy investment must meet the definition of investment under NAFTA Chapter 11. That is, it must fall within one of the enumerated categories of investment set out in NAFTA Article 1139. It must be an investment of an investor of another party, meaning that in our case, an enterprise, here of the US or Mexico, has made the investment. The investment must have been made in the territory of the party, here, Canada, and it must meet 2 temporal requirements. First, it must have been made, or in other words, established or acquired while NAFTA was in force. And second, it must have existed when CUSMA entered into force. What does it mean to be in existence when CUSMA entered into force? And this, I think, gets to the crux of the tribunal's question, number one. And there are a couple of places we can look to for guidance on this. The first is the definition of legacy investment itself. As we can see, the in existence phrase comes immediately after the requirement that the investment in question was made while NAFTA was in force. Contrary to the claimant's argument, it is not enough that the investment was established or acquired prior to CUSMA's entry into force. If that was enough, the in existence clause would be redundant. Instead, this suggests that in existence is a separate requirement and means continues as an investment. The second place we can look for guidance is NAFTA's definition of the term investment of an investor of a party. Given that the CUSMA parties decided to tie their consent to arbitrate legacy investment claims to the concepts of investment and investor contained in NAFTA rather than in CUSMA, the NAFTA definition of the same term of art, investment of an investor of a party, offers guidance as to the contemplated relationship between investment and investor. As you can see on slide 47, that relationship is one of ownership or control. An investment of an investor is one that is owned or controlled by that investor. So, for an investment to exist as an investment of an investor of a party at a given moment in time, it must be owned or controlled by that investor at that time. Putting this all together, to establish a legacy investment, a claimant must establish that it held the relevant investment with respect to which it brings its claim when CUSMA entered into force. All three CUSMA parties agree with this interpretation. As Mexico has explained, a claimant must prove that it owned or controlled the enterprise, that's the investment in question, among other times, as of the date of entry into force of CUSMA. The US has also stated that Annex 14C limits the submission of arbitration claims to those investors with ongoing investments in the host states after NAFTA's termination. In this way, the US explains that the definition of legacy investment signals the USMCA's preference for permitting claims by investors who maintained their investments as of the treaty's entry into force, as opposed to those investors who did not. The tribunal must take this agreement of the CUSMA parties into account in its interpretation of legacy investment and should accord it significant weight. The claimant appears to agree at paragraph 71 of its rejoinder that, and I quote, the USMCA requires tribunal to consider whether an investment existed on the date the USMCA went into force, end quote. But the elaboration of its argument makes clear that it prefers to read out this express final clause of the definition of legacy investment. As Canada has previously noted, it is not open to the claimant or to the tribunal to alter the terms of Canada's consent to arbitrate legacy claims. Each of the claimant's three arguments in this respect must be dismissed. First, the claimant argues that the incorporated NAFTA definitions of investment and investor essentially operate to erase the in existence clause. In particular, it argues that NAFTA's definition of investor includes the phrase has made an investment in the past tense, which means the tribunal can ignore the express temporal requirements of the legacy investment definition because NAFTA allows an investment to have been made in the past. Canada does not dispute that one of the ways to qualify as an investor of another party under NAFTA is to have made an investment in the past. In fact, to qualify as a legacy investment under CUSMA, the investor must have made the investment in the past while NAFTA was in force. Neither of these facts altered or operate to erase the added temporal requirement to hold the investment at the time the CUSMA entered into force. Second, the claimant argues that under NAFTA, the only relevant time to assess ownership or control of an investment is the date of the measures. Not only is the claimant's position incorrect under NAFTA, it does nothing to displace the express text of the inexistence clause. While owning or controlling the relevant investment at the time of the alleged breaches is a necessary condition of establishing a tribunal's jurisdiction under NAFTA Chapter 11, it is not sufficient to establish jurisdiction under CUSMA Annex 14C. The claimant's third argument that other tribunals have held that a claimant can bring a claim post-divestment similarly misses the mark. None of those tribunals were dealing with treaty text like that of CUSMA Annex 14C, nor did they foreclose the possibility that a second treaty with different rules might supplant that idea. In short, the claimant cannot avoid that CUSMA Annex 14C imposes jurisdictional requirements that are additional to those in NAFTA Chapter 11. One of those requirements is that the claimant hold the investment with respect to which it brings a claim at the time that CUSMA entered into force. And that brings us to the second part of our argument. The claimant has not established that it met this express requirement. To recall, the claimant alleges that its investments are interests in Prairie and certain of Prairie's assets and the 2018 NAFTA claim. Neither qualifies as a legacy investment. First and foremost, the parties agree that WCC sold its interests in Prairie and its assets on March 15th, 2019, long before CUSMA entered into force on July 1st, 2020. Accordingly, any interests the claimant previously held in Prairie and its assets do not qualify as a legacy investment, and Canada has not consented to arbitrate the 2022 claim with respect to them. Understanding that its interests in Prairie do not qualify as a legacy investment, the claimant's next argument is that it had an investment in the form of a NAFTA claim, which it does not precisely define. It is posited that a NAFTA claim can be an investment under NAFTA, either as a standalone claim to money or as an investment under subparagraph H of the definition of investment in Article 1139. Now, there's a long list of reasons why this argument cannot be sustained. Primary among them is that there is no basis in the treaty to find that a NAFTA claim qualifies as a protected investment under NAFTA. But the tribunal need not even decide that issue because the claimant has only alleged breaches in its 2022 NOA with respect to the treatment of its interests in Prairie. It has made no allegation of a violation of Section A of NAFTA or an allegation of damage with respect to its purported NAFTA claim investment. The claimant cannot rely on one alleged investment for purposes of establishing jurisdiction, while advancing liability and damages claims about a different investment over which the tribunal lacks jurisdiction. This point alone is sufficient to dismiss the claimant's remaining claim about having a legacy investment. The claimant has thus failed to establish that it has a legacy investment, and Canada has not consented to arbitrate its claim. The claimant's final attempt to establish jurisdiction is resort to equitable principles, such as estoppel and preclusion. The tribunal's jurisdiction is a question of law. If the tribunal finds that the claimant has not established that it meets the conditions of Canada's consent to arbitrate as a matter of law, then it cannot create jurisdiction anyway on the basis of equity. Neither CUSMA Annex 14C nor NAFTA Chapter 11 permit this result. The tribunal in Koch Industries versus Canada recently agreed. That tribunal was also constituted under CUSMA Annex 14C and NAFTA Chapter 11. It agreed that its jurisdiction is a matter of law and that estoppel could not step in as a solution if there was no jurisdiction legally. The same holds true for preclusion, such that it may be. Here, the tribunal need not reach the claimant's estoppel or preclusion arguments because the claimant has failed to establish that it held a legacy investment under CUSMA Annex 14C as a matter of law. In any event, Canada has spent considerable time today and in its written submissions explaining why there is no basis to the claimant's allegations on the facts either. We refer the tribunal to paragraphs 104 through 124 of Canada's reply and remain happy to answer any questions on these issues. In sum, The answer to the first question of whether the claimant has established it held a legacy investment under CUSMA Annex 14C is no. The consequence is dismissal, and the tribunal need not proceed further. And this is where I'll turn things over to Ms. Squires to kick things off on the suite of NAFTA issues the claimant has failed to establish.
Thank you. Ms. Squires?
Thank you. And good morning, Professor Kaufman-Kohler and members of the tribunal. My presentation this morning will address the proper interpretation of the waiver requirement in NAFTA Article 1121. And in doing so, explain a further reason why this tribunal is without jurisdiction. As Ms. Seaman mentioned, Canada has two arguments with respect to waiver. This also means that you'll hear from me twice this morning. At this juncture, I'm going to discuss Canada's first waiver argument, that this tribunal is without jurisdiction over the claimant's Article 1116 and Article 1117 claims, as the claimant and Prairie have failed to submit valid waivers as is required under Article 1121(3) of NAFTA. So let's turn to that argument. Along with other conditions precedent to arbitration in NAFTA, Article 1121 requires a claimant and its enterprise investment, if a claim has been submitted to arbitration under Article 1117, to waive its right to initiate or continue other proceedings for damages with respect to the measure alleged to breach the NAFTA, in order to crystallize Canada's consent to arbitrate and for a tribunal established under Section B of the NAFTA to have jurisdiction. Article 1121(3) explicitly indicates that a waiver must be in writing, delivered to the disputing party, and included in the submission of a claim to arbitration. As can be seen from the title of Article 1121, the filing of relevant waivers is a condition precedent to submission of a claim to arbitration. It clearly establishes that the parties consent to arbitrate under NAFTA is only given if the claimant complies with the procedures of the agreement, including the requirement of Article 1121(3) to provide a valid waiver. The jurisdictional nature of this article is important. It means that for there to be compliance with Article 1121, Canada must be in possession of both the notice of arbitration and valid waivers that waive future proceedings with respect to the measures identified in that notice of arbitration. Only once both have been received will Canada's consent be obtained and a tribunal validly constituted. When no waiver is provided, a state's offer to arbitrate and an investor's acceptance of the same do not meet. In such a case, no arbitration agreement has been formed. Any tribunal constituted on that basis will be deprived of jurisdiction. The case law is clear that a valid waiver must be received prior to constitution of the tribunal for that tribunal to have jurisdiction, and that only when both are received will a claim be submitted to arbitration for the purposes of Article 1121. For example, the tribunal in Pope and Talbot noted that before the tribunal entertained the claim, the waiver shall have been effected. The same points have been emphasized by the DIBC, Waste Management, and KBR NAFTA tribunals, and the tribunals in Renko and Gramercy Fund. The latter, who endorsed the position of the United States in that proceeding, in holding that where an effective waiver is filed subsequent to the notice of arbitration, but before constitution of the tribunal, the claim will be considered submitted to arbitration on the date on which the effective waiver was filed, assuming all other requirements have been satisfied, and not the date of the notice of arbitration. So what does this mean for the claimant here? The claimant argues that its claim was submitted to arbitration at the time it filed its notice of arbitration in this proceeding. However, for Canada to have consented to this arbitration as of that date on October 14th, 2022, and for this tribunal to have jurisdiction as of that same date, the claimant must have included valid waivers at the time of the notice of arbitration. When Canada received the claimant's NOA in this arbitration on October 14th, 2022, attached to it as exhibits C040 and C041 were two waivers, one for WCC and one for Prairie. The dates of those waivers was November 12th, 2018. These are the waivers that WCC and Prairie submitted in the 2018 proceeding. The claimant's argument that these waivers continue to be applicable and in effect, such that they would meet the requirements of Article 1121 for this proceeding, is untenable. As Ms. Zeman already explained, the 2018 waivers were withdrawn in 2019 along with the 2018 NOA. Therefore, as a factual matter, the claimant is incorrect. The claimant has not pointed to any authority that would support its view that if a notice of arbitration is withdrawn prior to the constitution of the tribunal, the waivers filed with that notice of arbitration continue to be effective. Second, the Prairie waiver that was filed and withdrawn in the 2018 proceeding was later used on Canada's consent as Prairie's waiver in the WMH proceeding. Again, the claimant has not pointed to any authority to say that the same waiver can be used to satisfy the requirements of Article 1121 in two separate proceedings. Nor has the claimant pointed to any authority for its proposition that waivers filed in a separate arbitration in 2018 can establish Canada's consent in this arbitration, where the NOA was received by Canada in 2022. The individuals that signed the 2018 waivers had the legal authority to bind the company at that time. The waiver of those legal rights was withdrawn in 2019. At the time the NOA was received by Canada in this arbitration in 2022, Canada had no evidence that the individuals that signed the waivers in 2018 had the ability to waive the legal rights of WCC or Prairie at the time Canada received that notice of arbitration. Canada raised this issue with the claimant on February 21st, 2023, prior to this tribunal being constituted on March 14th, 2023. In response to the claimant's statement that it was relying on the 2018 waivers in this arbitration. Canada specifically noted that the submission of and compliance with an effective waiver under Article 1121 is among the prerequisites to establish a NAFTA party's consent to arbitrate. That waivers filed in separate arbitration proceedings cannot constitute valid waivers for the purposes of the current claim. And that Canada disagrees that the waivers filed in the Westmoreland Coal Company and Prairie Mines and Royalties first claim in 2018 are still applicable and in effect. Canada also noted that its consent to arbitrate would not be given absent confirmation that the individuals who signed Exhibits C040 and C041 had the capacity to sign waivers on behalf of WCC and Prairie on the date of the notice of arbitration. No further response was given from the claimant at the time. Now in its final written submission and over 2 years after Canada's request to the claimant brings forth two pieces of information. With respect to WCC, in its rejoinder memorial at footnote 290, the claimant indicates that Mr. Hutchinson, the individual that signed the waiver on behalf of WCC in 2018, left the company prior to the submission of this claim to arbitration. Thus, as of 2022, Mr. Hutchinson did not have the legal capacity to waive the rights of WCC to initiate or continue proceedings with respect to measures alleged to breach the NAFTA. With respect to Prairie, the claimant asserts at footnote 290 as well that Mr. Micheletti, the individual that signed the waiver on behalf of Prairie in 2018, continued to have the authority to waive Prairie's rights on October 14, 2022, when WCC filed its NOA. yet it has presented no evidence in support of this untimely assertion, despite the burden to establish this tribunal's jurisdiction resting squarely on the claimant's shoulders. And this leads me to the claimant's offer that it is included in its rejoinder submission to file new waivers at this time. Canada does not accept this offer, and given the tribunal has already been constituted, the claimant's offer comes too late. This tribunal cannot grant leave to cure a defective waiver absent Canada's consent. As the tribunal in the Amarutu case held, doing so would be tantamount to the tribunal creating consent to jurisdiction when no such consent existed. Canada has provided no such consent here, and this tribunal cannot endow itself with jurisdiction. Nor would any acceptance of new waivers resolve the jurisdictional issues before this tribunal. In fact, such an acceptance would do nothing more than shift the date the claim is submitted to arbitration to today, thus emphasizing more the other jurisdictional issues faced by the claimant, such as those under the NAFTA limitation period. It would also mean that the claimant's claim was not submitted within the 3-year legacy period provided in CUSMA Article Annex 14C. The claimant fails to have considered that the resolution of one issue means failure on another. Now, with respect to the tribunal's fourth question, the tribunal has asked about the consequences of finding an expropriation claim remains following the claimant's withdrawal of its allegations with respect to the federal fuel charge for Canada's argument on the scope of WCC's waivers. If a residual expropriation claim exists based on Alberta measures alone, Canada's waiver argument does not change. Canada's Article 1121(3) objection is not based on the scope of the waivers filed in the 2018 proceedings, but rather that no waivers were filed at all in this proceeding. And as such, the claimant has failed to comply with the requirements of Article 1121(3). As a result, any changes to the scope of the measures alleged to breach NAFTA in this proceeding would not impact Canada's argument that the claimant and Prairie have failed to provide Canada with necessary waivers. With respect to the tribunal's fifth question, this tribunal has jurisdiction to determine whether valid waivers were filed before it. It also has the jurisdiction to determine whether the 2018 waivers were withdrawn with that claim and are therefore no longer effective. Both of these findings will confirm whether the claimant has waived its right to other recourse in the context of this specific proceeding. Canada cannot speak as to whether WCC would face other hurdles in bringing a claim before domestic court or otherwise. We would note, however, that such findings would not displace the fact that effective waivers from WMH and Prairie remain in place with respect to the measures alleged to breach the NAFTA in the WMH proceeding. In conclusion, the claimant's failure to meet the requirements of Article 1121(3) prior to the constitution of the tribunal means there is only one path forward. The claimant's claim must be rejected. Only a respondent state holds the discretion to decide whether to permit a claimant to either proceed under or remedy a defective waiver once the tribunal has been constituted, and Canada has provided no such consent here. I will now hand things over to my colleague, Ms. Dawson, who will walk the tribunal through Canada's arguments with respect to the limitation period.
Thank you. Ms. Dossman?
Good day. I will address the claimant's failure to establish this tribunal's jurisdiction ratione temporis. And one preliminary note, which is that for the purposes of my submissions, we will disregard that the limitation period in fact continues to run because of the claimant's failure to file effective waivers, as just explained by Ms. Squires. Unlike many treaties that provide for investor-state dispute settlement, NAFTA explicitly addresses the time aspect and the time limitation on claims. In Articles 1116.2 and 1117.2, the NAFTA parties set out clear rules governing the temporal aspect of a tribunal's jurisdiction. They specified that an investor may submit a claim to arbitration alleging a treaty breach and resulting loss, but also that a claim is not possible if more than 3 years have elapsed from the date of the investor's first knowledge of the alleged breach and loss. Article 1117.2 imposes the same 3-year limitation on claims by an investor on behalf of an enterprise that it owns or controls. These provisions contain no caveats, no exceptions, and no tribunal discretion to vary the 3-year period. Tribunals have approached the calculation of the temporal limitation by looking back from the date the claim was submitted to arbitration and setting a critical date or cutoff date 3 years prior. As we know, Article 1137.1 specifies that the date of the submission to arbitration is the date of receipt of the notice of arbitration. From there, we look back 3 years for the critical date. If the claimant learned of the alleged breach and loss prior to the critical date, the claim will be out of time. The claim before you today was submitted to arbitration when Canada received the claimant's notice of arbitration on October 14th, 2022. The critical date for the purposes of temporal consent is therefore October 14th, 2019. And according to the claimant, it first acquired knowledge of the alleged breaches and losses set out in the NOA on November 24th, 2016, years before the critical date. Therefore, this claim does not satisfy the requirements of NAFTA Chapter 11, Section B, and falls outside the scope of Canada's consent to arbitrate. This is a complete answer to the question of temporal jurisdiction. In the face of this evident jurisdictional bar, the claimant attempts to read in what it calls an international tolling principle to NAFTA. First, I'd like to step back and address what the claimant means by tolling. The claimant appears to be applying the principle that once a claim is properly submitted to arbitration and an agreement to arbitrate has been formed, a respondent cannot object on the basis of the limitation period 3 years later. That is not contested, but it is also not the situation before you. By tolling, the claimant is asking you to merge WCC's 2018 claim, which was withdrawn, and WMH's 2019 claim, which proceeded to a final award, with the 2022 claim that is before you today. For the claimant, it does not matter which investor brings the claim, under which treaty, with respect to which investment, and on which date. That view cannot be reconciled with the terms of the treaty. As Ms. Seaman explained, the submission of a claim to arbitration under NAFTA is what provides the framework for the potential agreement to arbitrate between Canada and the submitting investor. It is not enough that different notices of arbitration allege the same facts or that they arise out of the same challenged measures. To the contrary, our NAFTA Articles 1117.3 and the consolidation provisions in Article 1126 expressly recognize that there may be distinct agreements to arbitrate arising out of the same alleged measures and alleged harms. To return to the tribunal's second question, each of the 3 claims must independently meet NAFTA's jurisdictional requirements. The effect for the limitation period analysis is clear. This tribunal has jurisdiction only if it determines that WCC's submission of its claim to arbitration in 2022 meets the requirements of Articles 1116.2 and 1117.2. Now, with that core concept clarified, the claimant's arguments on temporal jurisdiction do not even achieve liftoff. The claim submitted to arbitration on October 14th, 2022, the claim before this tribunal, is out of time. In any event, should the tribunal wish to consider this tolling theory, there is no need to look further than the NAFTA itself. The claimant relies heavily on early arbitral cases. In those cases, the governing treaties did not contain express limitation periods. The arbitrators were required to determine if, in the absence of positive rules set out in the governing treaty, international law itself could operate to bar claims as untimely, and in that context, whether being on notice of a claim would suffice. These questions are inapplicable in the NAFTA context because the NAFTA parties agreed to clear positive rules regarding the time limitation of claims. As we saw in Article 1122, a NAFTA party consents to the submission of a claim to arbitration only, quote, in accordance with the procedures set out in this agreement. As the Corona Materials Tribunal explained with respect to the parallel provisions of the DR-CAFTA, Section B of Chapter 11 of NAFTA operates as lex specialis. There is no basis on which to read in a so-called international tolling principle into the treaty, or to find that the tribunal has the power to vary the 3-year limitation period. That is also the view of the NAFTA parties and of NAFTA tribunals interpreting the relevant provisions. As Mexico confirms, there is no possibility for the limitation period to be suspended. The United States agrees that the limitation period is not subject to any suspension or other qualification. And this is consistent with the purpose of limitation periods, which includes not only the preservation of evidence, but also a guarantee of finality for respondent states. It is also consistent with the findings of NAFTA tribunals, including Resolute and Feldman. The claimant has placed a great deal of weight on the Feldman Tribunal's mention of theoretical potential circumstances that could interrupt the limitation period. As the dissenting arbitrator in Renko 2 noted, this reflects the possibility that a respondent state is free to agree to vary the limitation period. And on the topic of Renko 2, I'd like to refer the tribunal to Canada's reply memorial at paragraphs 138 to 142, which sets out the many and varied differences between that case and this one. The claimant next attempts to bolster its case by stating that other respondent states have not objected to the jurisdiction of a tribunal constituted after an earlier claim has failed for lack of jurisdiction. The claimant here is incorrect. Canada is aware of 3 occasions, in addition to this one, in which respondent states have insisted that a subsequent claim must independently meet the treaty's jurisdictional requirements. In the interest of time, I will simply identify them, and the references also appear on slides 84 to 86 before you. The cases are Methanex and Mexico, Waste Management and Mexico, and most recently, Amaror 2 and Peru 2. In summary, absent the respondent's agreement, NAFTA does not provide for the suspension of the 3-year limitation period. But the claimant goes even farther. It seeks to expand its so-called tolling principle to capture claims made by different claimants, as well as to claims that have been withdrawn. Here, it appeals to civil codes of various jurisdictions and to court cases from Michigan. Now, far from showing anything universal, the claimant's examples in fact show that legislatures can and do set out different and detailed conditions, requirements, exceptions, and special circumstances if and when they want to allow for tolling. For example, here the statute spells it out. The limitation period The statutes of limitations are told when, ... The NAFTA parties could have included something similar in Chapter 11. They did not. Instead, they agreed to a clear and rigid 3-year limitation period with no exceptions or provisions for special circumstances. And although given many opportunities, the claimant has also not identified any authority for the proposition that a withdrawn claim could serve in any way as a basis for tolling of a limitation period. Perhaps as a result, the claimant has put forward in its rejoinder the statement that this was not a, quote, true withdrawal. A claim is withdrawn or it is not. There should be no dispute that the claim WCC submitted in 2018 was withdrawn in 2019. The claimant has also argued that Canada should be stopped and precluded from presenting jurisdictional arguments based on this withdrawal, and that doing so constitutes an abuse of rights. The claimant is again incorrect for the reasons set out in Canada's Memorial on Jurisdiction at paragraphs 105 to 122 and Canada's Reply Memorial at paragraphs 159 to 165. We don't propose to elaborate on those points today, but we are happy to do so tomorrow if that would be helpful. Finally, in its submissions on the limitation period, the claimant makes the argument that it is entitled to a hearing on the merits. Here, I'll simply draw the tribunal's attention to Article 1115, the first article in Section B, and the one that sets out its purpose. Its purpose is to, quote, assure equal treatment among investors of the parties in accordance with the principle of international reciprocity and due process before an impartial tribunal. This includes the question of the adjudication of whether an agreement to arbitrate even exists with respect to a particular claim. It does not include a right to be heard on the merits. A claimant must first establish that the claim meets the conditions of state consent, meaning that an agreement to arbitrate has been formed. And the claimant here has not done so. Finally, for me, with respect to question 4, to the extent that there is a residual expropriation claim, Canada's position remains the same. Such an allegation would fall outside the scope of Canada's agreement to arbitrate because the claimant has acknowledged that it knew of the alleged breach and loss on November 24th, 2016, more than 3 years prior to the notice of arbitration that launched this proceeding. And I would add that even on the claimant's theory, an expropriation claim is out of time. The 2022 claim is the first time that an alleged violation of Article 1110 has appeared in one of the notices of arbitration. An allegation of breach and loss that was not made in a prior claim cannot in any world have been told. For all of these reasons, the claimant's entire claim must be dismissed for lack of jurisdiction ratione temporis. And as Ms. Zeman noted, any one of these first 3 jurisdictional objections means that the claim cannot proceed. It is only in the event that all 3 are overcome that the tribunal need consider Canada's remaining jurisdictional objections. And I'll now turn things over to Ms. Harris to address Canada's 4th objection, for which we are going to do a bit of changing of chairs. Thank you.
Thank you. Ms. Harris?
Good afternoon, members of the tribunal. I will address why the claimant has failed to make out a prima facie damages claim under Article 1116(1) and therefore lacks standing. As Ms. Seaman explained earlier, the claimant's alleged damages are only those of its former Canadian enterprise, Prairie. Specifically, the claimant alleges damages for lost revenues from Prairie's coal sales and for Prairie's accelerated reclamation costs. These are damages that cannot be claimed under Article 1116 because they are not direct damages to WCC. The requirement for a claimant to show prima facie damages at the jurisdictional stage is clear from the text of Article 1116(1), which permits an investor to bring a claim on its own behalf, alleging that the investor has incurred loss or damage. As set out in Canada's memorial at footnote 227, tribunals have confirmed this requirement. Therefore, to establish standing under Article 1116, WCC must establish on a prima facie basis that it has itself incurred loss or damage from the alleged breaches of NAFTA. And though this is not a high threshold to meet, in that WCC need only plead facts sufficient to be regarded as true to support a claim for direct loss or damage, it has failed to do so. And this is so because WCC has not asserted any loss that it has self-incurred separate from the loss allegedly suffered by Prairie. Examples of direct injury that a shareholder investor could recover for under Article 1116 include damage as a result of the loss of voting rights, the loss of the right to receive dividends, the loss of an ability to transfer share ownership, or the loss of a right to acquire further shares. Although this is not an exhaustive list, what all these examples share in common is that they are damages associated with the rights and entitlements of a shareholder investor. Article 1116(1) is to be contrasted with Article 1117(1), which gives an investor standing to bring a claim on behalf of an enterprise that it owns or controls, where the enterprise has incurred loss or damage as a result of the challenged measures. Under Article 1117, a claim could be brought on behalf of a corporate enterprise owned or controlled by the investor for damages as a result of loss in the value of an enterprise's assets, a loss in value of the corporation's shares due to measures affecting its overall viability, or lost profits if they can be proven with sufficient certainty. Importantly, any award of damages for a claim under Article 1117(1) is paid to the enterprise and not to the investor, pursuant to NAFTA Article 1135(2)(b). The effect of this is to ensure that when an investor recovers damages on behalf of the enterprise, the interests of others in that enterprise are respected, such as creditors and minority shareholders. The claimant overlooks the fact that the NAFTA parties have consistently interpreted Articles 1116 and 1117 as addressing discrete, non-overlapping types of injury, and that a claim for indirect injury to an investor based on direct injury to the enterprise or reflective loss is not recoverable under Article 1116. The NAFTA parties' agreement in this regard was affirmed in the recent non-disputing party submissions of the US and Mexico. NAFTA tribunals have also recognized this distinction, and Canada discusses these cases at paragraphs 219 to 222 of its reply. With this in mind, let's now turn to WCC's claim for damages.
At paragraph 94 of its notice of arbitration, the claimant alleges that Canada's actions at the provincial and federal levels eliminated the market for thermal coal and essentially left Westmoreland with worthless interests in the Genesee, Sheerness, and Paint Earth mines, while saddling Westmoreland with significant reclamation costs. Although the claimant refers to Westmoreland, what it describes, as we have previously summarized, appears at most to be indirect loss arising from alleged damage to prairie. WCC's claim is essentially one for reflective loss, which cannot be brought under Article 1116. To counter Canada's position that claims for reflective loss are not recoverable under Article 1116, in its response, the claimant argues, at paragraph 144, that this is not a case of reflective loss because WCC is challenging Canada's conduct that resulted in the total destruction of WCC's investment. But the claimant provides no explanation on how its shares in Prairie or Prairie's operations were totally destroyed. From the information on record, we know that WCC continued to own its shares in Prairie for many years after Alberta adopted the challenge measures, and these shares were eventually sold to WMH in the context of its US bankruptcy proceedings. We also know that Prairie continued to operate after the challenged measures. The claimant attempts to provide clarification in its rejoinder by stating that despite holding shares in Prairie following the measures, WCC had significant write-offs on its own books after emerging from the bankruptcy. But this was the first time the claimant raised this point without any specificity and without any connection to the particular damages it claimed in its NOA. Its late attempt does not meet the low threshold of asserting prima facie damages under Article 1116. Since the claimant has not pled facts that, as alleged, can substantiate a claim of direct loss or damage to WCC, apart from that allegedly incurred by Prairie, the claimant has not made out a prima facie damages claim, and as such, its Article 1116 claim must be dismissed. If anything, this is a claim for damage that falls under Article 1117. But as my colleagues will explain shortly, WCC also fails to meet the requirements to submit a claim under Article 1117. I will now turn it over to my colleague, Ms. Squires.
Hello, everyone again. I'm here before you now to discuss Canada's second argument with respect to Article 1121. As the tribunal will recall, in the WMH proceeding, Prairie provided a waiver pursuant to Article 1121(3) of NAFTA, waiving its right to initiate or continue other dispute settlement proceedings with respect to the measure alleged to breach NAFTA in that proceeding. As a result of that waiver, there can be no basis upon which a second proceeding with respect to those measures can be commenced on behalf of Prairie by WCC under NAFTA Article 1117. Article 1121(2)(b) requires an enterprise to waive its right to initiate or continue before any administrative tribunal or court under the law of any party or other dispute settlement procedures, any proceeding with respect to the measure of the disputing party that is alleged to be a breach referred to in Article 1117. The only exception to this requirement is also explicitly stated in that same article. Proceedings for injunctive, declaratory, or other extraordinary relief not involving the payment of damages. This is what's referred to as the material requirement of the waiver provision, which, when combined with the formal requirement requires a claimant to not only submit a valid waiver, but act consistently with that waiver, as was clearly stated by the tribunal in Waste Management 2. As such, once Prairie submitted its waiver in the WMH proceeding, it was barred from having any claimant initiate any other proceeding for damages on its behalf under Article 1117 of NAFTA if those proceedings were with respect to the measure alleged to breach the NAFTA in the WMH proceeding. The claimant argues that this proceeding does not fall within the scope of the waiver submitted by Prairie in the WMH proceeding for two reasons. First, that the term other dispute settlement procedures only requires a claimant to waive their right to dispute settlement procedures that are distinct from their chosen investment arbitration procedure. And second, that even if this is not the case, Article 1121 does not prevent the tribunal from finding jurisdiction, as there is a fundamental rule in international law that, to quote the claimant, does not prevent an investor whose claims were dismissed on curable, procedural, or jurisdictional grounds from recommencing arbitration a second time after curing the defect. On the first point, the phrase other dispute settlement procedures in Article 1121 2b necessarily captures other NAFTA proceedings. The claimant's argument that Article 1121 requires only the waiver of proceedings other than the procedure selected by the investor is incorrect. This approach runs counter to the text's ordinary meaning and reads out the express and unambiguous terms of the provision, which includes no such exception. The only exception to the material requirement in Article 1121 is proceedings for injunctive, declaratory, or other extraordinary relief not involving the payment of damages. The phrase other dispute settlement procedures cannot be interpreted as carving back in proceedings that would otherwise fall under the exception, such as other NAFTA proceedings where requests for damages have been made. The claimant's view would in effect allow multiple proceedings for damages to be brought against the respondent state. This is inconsistent with the provision's purpose, which is to minimize the risk of double recovery. The limited and very specific exception to Article 1121 contains no scope for the possibility of duplicative proceedings that may lead to conflicting outcomes on both law and fact. Canada's argument stands even if the first NAFTA proceeding that is commenced by a claimant is later dismissed for want of jurisdiction, which is the second point raised by the claimant. The claimant's heavy and exclusive reliance on the Waste Management 2 and Murphy 2 decisions for this argument are of little use. First, the Murphy 2 decision interprets different treaty text that is not contained in Article 1121 and involves a factual circumstance arising out of Ecuador's withdrawal from the ICSID Convention that does not arise here. It is not applicable to the situation at hand from both a legal and factual perspective. Second, the Waste Management 2 Tribunal's finding that the express terms of NAFTA do not preclude a claimant from commencing an arbitration a second time, specifically noted that the second proceedings must be in compliance with the prerequisites of submission of a claim to arbitration. The specific reason the claimant was able to comply with those prerequisites to Mexico's consent in that second proceeding was the lack of an effective waiver under Article 1121 in the prior proceeding. That is decisively not the case here, where an effective waiver was filed by Prairie in the WMH proceeding. Despite 3 written submissions in this proceeding, the claimant has still failed to directly address this fundamental difference. The claimant's exact argument was dismissed by the Amarutu Tribunal, who, in interpreting the same text in a different treaty, held that such an interpretation would in fact amount to an impermissible rewriting of the treaty text. There is simply no textual support for the claimant's attempt to read into the limited exception in Article 1121 claims that may eventually be dismissed by a tribunal for lack of jurisdiction. As the waiver filed by Prairie in the WMH proceeding continues to be effective, the claimant's attempt to commence a second proceeding on behalf of Prairie under Article 1117(1) is inconsistent with that waiver. This tribunal is without jurisdiction, and the claimant's Article 1117 claim must be dismissed. That ends my presentation this morning, and I will now pass things over to Mr. Koziel, who will speak to Canada's next jurisdictional objection.
Thank you. And you know, Mr. Koziel, that there's not much time left.
Yes.
On my count, there's 3 minutes, but if you need a little bit more, we'll give it to you, and then we'll give the same to the claimants, of course.
Thank you very much. I will endeavor to be efficient this morning and keep my concluding remarks very brief. Good morning. My presentation today will address the proper interpretation of NAFTA Article 1117(1) and provide an additional reason why this tribunal lacks jurisdiction to hear the claimant's Article 1117 claim. NAFTA Article 1117(1) allows an investor to bring a claim on behalf of an enterprise that it owns or controls at the time that claim is submitted to arbitration. The claimant cannot establish this tribunal's jurisdiction over its Article 1117(1) claim, which it makes on behalf of Prairie, because it did not own or control Prairie at the time it filed its 2022 Notice of Arbitration. This is because the claimant sold Prairie to WMH on March 15th, 2019, more than 3 years prior. Before I turn to the arguments made by the claimant, I want to take a brief moment to describe the specific purpose of Article 1117(1). As you know, a bedrock principle of customary international law is that no international claim may be asserted against a state on behalf of that state's own nationals. In practice, however, investors often choose to make an investment through a separate enterprise, such as a corporation that is incorporated in the host state. If the host state were to injure that enterprise in a manner that does not directly injure the investor, then no remedy would ordinarily be available under customary international law. Article 1117(1) addressed this by creating a limited derogation from customary international law to allow investors to make claims against a host state on behalf of their enterprise incorporated in that state. This derogation was carefully circumscribed by the 3 NAFTA parties through the addition of an express temporal condition on the claimant's ownership or control of its enterprise investment. Now, with respect to the claimant's Article 1117(1) claim, the claimant argues that the only time it needs to own or control the enterprise on whose behalf it brings the claim is at the time of the challenge measures. The claimant contends that Canada's interpretation of Article 1117(1) is incorrect and rests, quote, entirely on the present tense use of the words owns or controls in Article 1117(1), end quote. But this is not accurate. Canada's interpretation of this provision flows from, yes, the express terms of Article 1117(1), but also the clear and consistent understanding of all 3 NAFTA parties on its meaning, and relevant investment jurisprudence that confirms that understanding. I will start with the terms of the provision itself, which are on your screen. Its meaning is clear. The present tense formulation of the phrase owns or controls in the text of Article 1117(1) is an express temporal condition. It means that you can only bring a claim on behalf of an enterprise that you own or control at the time your claim is submitted to arbitration. The 3 NAFTA parties were alive to the use of different temporal tenses when they negotiated NAFTA Chapter 11. For example, Article 1139 defines the term investor to capture 3 temporal tenses: an investment that the investor seeks to make, is making, or has made. In Article 1117(1), the NAFTA parties chose the present tense, and in so doing, deliberately excluded enterprise investments that the investor previously, but no longer, owns or controls. This is reflected in the clear and consistent understanding of the 3 NAFTA parties, a point the claimant has never addressed, either in its response or its rejoinder. Finally, Canada's interpretation and the clear and consistent understanding of the 3 NAFTA parties is confirmed by the relevant findings of NAFTA tribunals. The claimant has argued that its position on Article 1117(1) is consistent with the interpretation of investment tribunals constituted under NAFTA, as well as under other treaties. However, as Canada pointed out in its reply, these are overwhelmingly non-NAFTA cases decided under other treaties. Those other treaties did not contain an analogous provision to Article 1117(1), including its express temporal ownership requirement. In many of the cases the claimant relies on, ownership of the investment was not even at issue at the time the claim was submitted to arbitration. The only NAFTA cases in which a tribunal was directly seized with the issue of ownership or control of an enterprise investment at the time of filing an Article 1117(1) claim are BMEX and Lowen. Both of those tribunals found that Article 1117(1) requires an investor to demonstrate ownership or control of the enterprise at the time it submits a claim to arbitration on that enterprise's behalf. In its rejoinder, the claimant offers no response to those directly relevant tribunal findings. In sum, the claimant's position that the only time it needs to own or control the enterprise on whose behalf it brings a claim is at the time of the challenge measures, reads out the express text of the treaty provision, relies on cases that do not support its position, and does not engage with the fact that all 3 NAFTA parties have consistently shared the same view of what this provision means. Consequently, the claimant has failed to establish this tribunal's jurisdiction over its Article 1117(1) claim because it did not own or control Prairie when it submitted this claim to arbitration in October 2022. To conclude, you will recall that we began this morning with a fundamental principle. Investor-state arbitration is a creature of consent. Canada's consent to arbitrate an investor's claim under CUSMA Annex 14C and NAFTA Chapter 11 is subject to a number of conditions. For all of the reasons my colleagues and I have put to you today, Canada has demonstrated how the claimant has failed to satisfy each of the conditions that are relevant in this case. Therefore, Canada respectfully requests that the claimant's claim be dismissed in its entirety for lack of jurisdiction. Thank you, and that concludes Canada's presentation this morning.
Thank you very much to all 5 of you. If I'm not mistaken, and the secretary will correct me, you have used 1 hour, 1 minute. Is that correct, Anna? I don't hear you.
Sorry, that is the same as my count.
Good, excellent. Of course, the claimant can use the same time if it needs to. We have now provided that we would have a break of 15 minutes. This is what we will do, and we'll resume in 15 minutes from now. Can the secretary please bring people into their breakout rooms? Thank you.
Very good.
Yes, that's good. So if everyone's back, and that's what I gather from the number of connections that I see, I can give the floor now to the claimants for their oral presentation. Mr. Rubenstein, can I give the floor to you? You're on mute.
Can you hear us now?
Now is fine, yes.
Okay, excellent. Thank you, Madam President. Good afternoon, members of the Tribunal and Secretariat. On behalf of the claimant, Westmoreland Coal Company, we want to thank you for giving us the opportunity to address Canada's jurisdictional objections. Ms. Friedman and I will be presenting the claimant's opening argument on jurisdiction. Before we get into the detail, I want to start by providing an overview of the claimant's position, since there's a lot of ground to cover given the volume of Canada's objections. While the history of this case is long, the factual record is relatively straightforward and for the most part uncontested. As explained in the notice of arbitration, WCC's claims arise from Alberta's climate leadership plan to accelerate its transition away from coal, shortening the transition period from 50 years to approximately 15 years. And that acceleration occurred only 1 year after WCC acquired the mines at issue. In November 2016, Alberta announced a program to compensate coal companies for the stranded capital they would face due to the significant acceleration of the coal transition, paying $1.4 billion to 3 Canadian coal companies, while at the same time.
Excuse me, Council, apologies. This is Dawn Larson, the stenographer. There seems to be some feedback with your microphone when you pause, and it's kind of cutting out your words a little bit. If there's any way we could correct that, that would be fabulous.
All right, we'll see what we can do on our end here.
I wasn't hearing it before. It's almost as if when you pause, then some feedback comes in.
Is there any way to get the microphone closer? It's a nudge. Okay, well, let us know if that problem continues, and if it does, we'll see what we can do to fix it.
That sounds a little bit better already. And if you could start over with in November 2016, Alberta announced, please.
Certainly. In November 2016, Alberta announced a program to compensate coal companies for the stranded capital they would face due to this significant acceleration of the coal transition, paying $1.4 billion to 3 Canadian coal companies, while at the same time refusing to provide any compensation to WCC, the only non-Canadian coal company affected. WCC filed its NAFTA claim against Canada on November 19, 2018. WCC then, in the midst of the arbitration, was forced into bankruptcy, in part due to the measures that are challenged in this proceeding. Pursuant to the bankruptcy, WCC purported to transfer its claim to WMH and sought as a result to add WMH as a co-claimant in its May 13, 2019 amended notice of arbitration. As explained this morning, Canada objected to that amendment, proposing instead as a, quote, solution, unquote, that WCC withdraw its notice of arbitration so that WMH could be substituted as the sole claimant. WCC accepted Canada's proposal, although it disagreed with Canada's objection. It accepted the proposal as, quote, a fair compromise, close quote, so that the arbitration could, quote, proceed without unnecessary procedural delay, close quote. Yet immediately following the implementation of the proposed substitution, Canada immediately challenged WMH's standing, thereby producing the very delay that WCC was seeking to avoid. WMH was shocked and complained to the Westmoreland 1 Tribunal, citing Canada's lack of good faith and the principle against self-contradiction. Apparently seeking to minimize the obvious unfairness of its tactic, Canada assured the Westmoreland I Tribunal that WCC still could pursue its claim, notwithstanding the withdrawal of its earlier notice of arbitration. The tribunal in Westmoreland I then issued its award on January 31st, 2022, accepting Canada's position that WMH had no standing because WCC was the proper claimant. Following the award, WCC went back to the US Bankruptcy Court to confirm that WCC still owned the NAFTA claim in light of the Westmoreland I award, and that WCC still had the authority to resubmit the claim that it had originally commenced in 2018. Following the court's order to that effect, WCC re-notified and resubmitted the NAFTA claim that is now before you. Despite its representations to the Westmoreland I Tribunal, Canada now argues that WCC's claim is barred due to a series of jurisdictional objections, none of which were mentioned to the Westmoreland I Tribunal. For the reasons that we will explain, Canada's jurisdictional objections are meritless and should be rejected. Here's an overview of the points that we will be covering this afternoon. Ms. Friedman will begin by explaining why WCC's claim qualifies as a legacy claim under the US-Mexico-Canada Agreement. We will then address why the tribunal has jurisdiction under the NAFTA. Specifically, I will explain why WCC's claims are timely under the NAFTA. Ms. Friedman will then address why WCC's original 2018 waivers were sufficient to comply with the NAFTA waiver requirement, why WCC has standing to assert an 1117 claim on behalf of Prairie, and why Canada's reflective loss objection is meritless. I will then conclude by addressing why Canada should be stopped and precluded from challenging the tribunal's jurisdiction based on its statements and conduct during the Westmoreland I proceedings, and why well-established principles of international law require that WCC's claim be heard on the merits now that the jurisdictional defect cited in Westmoreland I has been cured. And with that, I will pass it to Ms. Friedman.
Ms. Friedman, please.
Before I get into the terms of the USMCA, I want to provide what I hope will be helpful background. The measures at issue in this arbitration took place while the NAFTA was in force, and WCC asserted a claim against Canada while the NAFTA was in force. And while that NAFTA arbitration was pending, the USMCA replaced NAFTA. But even after that, Canada assured the tribunal that WCC could still bring a claim. In its reply on jurisdiction in 2021, Canada said, quote, it was open to WCC to continue its claim, end quote.
I'm sorry, I don't know how it is for the court reporter, but we get all kinds of interfering sounds.
Yes, I'm hearing it also, please.
Okay, perhaps we could take a short break just to reconfigure the volume set, the audio setup.
Yes, that is a good
apologize.
idea.
We're not gonna, okay.
That's fine.
Thank you very much, and we'll take it as quickly as possible. Any preference?
I think you can continue unless Ms. Larson tells us otherwise, but it was audible. It was just not very clear, but the transcript seems fine.
Okay.
I'm good too. Thank you very much.
So when Canada submitted its reply on jurisdiction, it said that WCC, it was still open to WCC to submit a claim to arbitration. And Canada noted at that time that it wasn't going to take a position on jurisdiction. So at the final hearing, arbitrator Hosking pressed Canada on this and asked whether or not WCC had residual rights to bring a claim. Canada did not respond at that hearing. No, the USMCA is in force now, it's too late. Instead, Canada responded that WCC could still be in a position to bring a claim on its own behalf. Canada was right because WCC was and is entitled to bring a claim on its own behalf for multiple reasons, including because it benefits from legacy protection. Now, given the Vienna Convention requirements on treaty interpretation, I'm going to start with the object and purpose of the legacy provision, and then I'll turn to the plain language of the USMCA. I'll then explain why, even if the tribunal were to accept Canada's view on the legacy provision, WCC still has a legacy claim. Later, Mr. Rubenstein will explain why Canada should be stopped from asserting its legacy investment provision defense in the first place. So starting with the object and purpose of the legacy clause. The USMCA itself provides the best evidence of the purpose of legacy protection. Article 14.2.3 states that the legacy clause provides protection for acts that took place before the USMCA went into force. That is, it's retroactive. And this is important because this is the only part of the USMCA that applies to prior acts. So think about that for a moment. It makes no sense to apply the USMCA to prior acts, but to deny protection to investors who are completely deprived of their investments by those prior acts. Denying protection to investors who lost their investments due to past acts would destroy the protection against past acts. It would destroy Article 14.2.3 altogether. Now, to provide protection against past acts, the legacy clause preserves claims that arose before the USMCA went into force. All of the available evidence confirms that the focus of the legacy clause was to preserve prior claims. The USTR, which was the agency, the US agency that negotiated the USMCA with Mexico and Canada, produced talking points during the course of negotiations, and some of those are on the slide. As those talking points confirm, Annex 14C is a grandfather clause that allows investors to bring claims where the breach took place before the USMCA went into force. A grandfather clause works by ensuring that those who would have had protection continue to have protection. It essentially freezes the status quo for those who are protected. And here, the status quo is frozen for 3 years. Now, WCC had protection under the NAFTA and therefore had and has legacy protection for 3 years under the USMCA. Statements from the Mexican, US, and Canadian officials at the time that the USMCA went into force also confirmed that the legacy clause was meant to preserve claims. Those announcements confirmed that claims could still be brought forward for investments made prior to entry of force of the USMCA. We cited a statement on the slide here, and we have references to other examples on slide 10. Now, there's no evidence anywhere in the record or anywhere in the public record that the contracting parties intended to abruptly terminate protection for past acts. Canada has not explained what the object and purpose of legacy protection is, let alone has Canada provided any evidence that would support an interpretation that's consistent with its view. Canada should have full access to the object and purpose of the USMCA because it sat at the negotiating table. If there were evidence that supported Canada's view, Canada would have provided it. Canada provided nothing. Now, Mexico and the United States submitted Article 1128 submissions in this arbitration. Canada argued this morning that the non-disputing parties take Canada's side on legacy protection. But the quote that Canada cites from Mexico's Article 1128 submission is taken entirely out of context, because Mexico made that comment that it cited in the context of its discussion of Article 1117. So I suggest that the tribunal go back to Mexico's submission to confirm what Mexico, in the context in which Mexico made that statement. Now, if Mexico intended to state otherwise, that position was unreasoned. Canada also cited to the United States defensive pleading and TC Energy to support its position. But arguments that a state party like the US and TC Energy makes is, while defending their own interests, cannot be taken as evidence of what the treaty means. And that's because a contracting state can take a position simply to adopt its own interests. And it would be unfair to investors, and it would also undermine the purpose of treaty protection to afford any weight to those statements. Now, so Mexico and the United States did not dispute WCC's interpretation of their publications. The ones that I just referred to, the USTR statement, for example. On the contrary, Mexico confirmed that the ordinary purpose of Article 14C preserves the ability to submit claims to arbitration alleging NAFTA breaches in relation to facts that took place before the NAFTA was terminated. So again, more evidence that the purpose of the USMCA is to preserve NAFTA protection. Mexico also confirmed that NAFTA breaches could only have occurred before the NAFTA was terminated. And the US took this same position in its Article 1128 submission in Volcan v. Mexico, which is on the record. Now, if NAFTA breaches could only have occurred before the NAFTA was terminated, then requiring ownership on July 1, 2020 would make even less sense, because legacy protection would not provide protection at any time whatsoever. The plain text of the USMCA also supports WCC's position. The tribunal asked the parties what it means for a legacy investment to be in existence when the USMCA went into force. Now, in order to answer that question, you have to look to both the USMCA and to the NAFTA terms that are incorporated into the USMCA. A legacy investment is in existence when the USMCA went into force if, on that date, it would have qualified as an investment of an investor under the NAFTA. That's what the legacy provision says. And this is the only possible conclusion because the terms of the treaty must be interpreted as a whole and not in isolation. That's a basic principle of the Vienna Convention, which requires that a treaty be interpreted according to its terms, plural, and in their context with reference to other terms in the treaty. Now, Canada argued this morning that we're omitting the term in existence from our analysis. We are not. We are properly defining the term in existence by reference to the specific terms that govern what it means to be in existence. Here, the NAFTA. Here, in this case, WCC's investment in Prairie was in existence on July 1, 2020, because it met the definitions of investment of an investor on that date. So I'm going to go a little bit deeper into the substance of this. And I'll start with the plain language of the NAFTA. And these are the terms that were incorporated into the USMCA. We have them on slide 13. Now, the relevant terms are Article 1139, Article 1116. 1139 is the definitions clause, 1116 is the NAFTA standing clause. Now, all of these definitions are framed in the past tense. And the reason that all the relevant NAFTA clauses are framed in the past tense is because they're designed to provide protection to investments of investors based on ownership at the time of the measures. So Article 1139, an investment of an investor, the exact term of art used in the USMCA, is defined as an investment that is owned or controlled by, the investor. That's in the past tense. Investor of a party is one that either seeks to make, is making, or has made an investment. Again, includes the past tense. And finally, and importantly, Article 1116 allows an investor to submit a claim to arbitration if it's incurred loss or damage by reason of or arising out of the breach. Again, looking at the past tense. Now, Canada this morning argued that we say you only have to comply with the term investment or investor. We actually say an investor has to comply with all three requirements in order to be able to submit a claim to arbitration under the NAFTA. And we also submit is that if the NAFTA contract, or if the USMCA contracting parties wanted to limit coverage to investors that still owned their investment on July 1, 2020, they would have used the USMCA definition of investment, which is in the present tense, it owns or controls. They intentionally referred back to these past tense definitions. Now, because of this, NAFTA tribunals always look to the date of the measure to determine the protected investor and investment. And this is not specific to the NAFTA. This is across investment treaty jurisprudence, but specifically to the NAFTA, the same principles apply. Most relevant to this case, the Westmoreland Tribunal applied the NAFTA and found that it imposed two requirements. First, that the investor must have held the investment at the time of the alleged breach. And second, that the investor must have suffered loss or damage arising out of the breach. The tribunal did not find a third requirement, that the investor owned the investment at the time it submitted the claim to arbitration or at any other present time. Now, the reason the Westmoreland Tribunal didn't include a third requirement is because it's legally irrelevant. It's not relevant as long as the investor owned the investment at the time of the breach. The Mondev Tribunal gave the policy reasons why, as have many other tribunals, which is essentially that requiring an investor to remain an investor would frustrate the purpose of investment treaties, because if a state can take acts that deprive the investor of their investment, there's no investment protection whatsoever. There's more proof that the only relevant date is the date of the measures. In negotiating the NAFTA, Canada repeatedly tried to insert a continuous ownership requirement, and some of its proposals are on the slide. Now, despite Canada's proposals for a continuous ownership requirement, that limitation never made it into Article 1139. It never made it into Article 1116 either. The fact that the NAFTA parties discussed continuous ownership but did not incorporate it confirms that the NAFTA parties did not intend to requirement. And again, the only date that matters is the date of the measures. Now, let's apply the relevant NAFTA definitions to the USMCA Legacy Clause. On the left of slide 16 is the USMCA Legacy Clause, and on the right are the NAFTA definitions that are incorporated into the Legacy Clause. So to be a legacy investment, you must be an investment of an investor that acquired or established the investment between 94 and the date of entry force of the USMCA. And you must be an investment of an investor that existed on the date that the USMCA went into force. Now, WCC complies with both requirements. The first one is not contested. WCC complies with the requirement. Apologies, we're having technical. Also complies with the requirement that that the investor owned the investment, have owned the investment, has made an investment, and has incurred loss or damage, and it complied with each of those requirements on July 1, 2020. Therefore, WCC has a legacy investment as defined under the USMCA, and we hope that's answered the tribunal's question. Oh, Canada agreed in its memorial on jurisdiction that the tribunal should look to the NAFTA to define what is meant by an investment of an investor under the Legacy Clause. That's at paragraph 84 of its memorial on jurisdiction. Canada also agreed that investment tribunals, including NAFTA tribunals, find that a claimant needs to hold the investment only at the time of the breach. And Canada said in its briefing, it does not seek to depart from this well-founded principle. Because Canada cannot dispute these basic principles, Canada in its briefings invented an additional NAFTA requirement that it argues was also incorporated into the USMCA. You have Canada's argument on slide 18. Canada argued that NAFTA tribunals have consistently applied Article 1101 to require a legally significant connection between challenge measures and the claimant and its investments, which it calls the immediate and direct effects test. It says that the same reasoning applies to the USMCA Annex 14C the language investment of an investor of a party in existence on the date of entry into force requires the claimant to have held the investment at issue on July 1, 2020. So Canada, at the time that it submitted its briefs, accepted the exact way that WCC has interpreted the legacy provision, except that it tried to invent or incorporate another requirement based on NAFTA precedent. Now, I'll first start with Canada's original argument, which is that this unsettled precedent of an immediate and direct effect should be incorporated into the legacy clause. Now, it really remains to be seen whether the NAFTA imposes an immediate and direct effect requirement. Most tribunals, including Cargill, Apotex, and Canadian Cattlemen, have rejected that requirement. So it's really inconceivable that the USMCA drafters meant to incorporate such an unsettled principle into the USMCA legacy provision.
I'm sorry, Council, if you could slow down just a little. I'm still getting quite a bit of feedback, and it's really hard to hear some of the words right before you pause. It breaks up a little bit. The last thing I have is, so it's really inconceivable that the USMCA drafters something.
Yeah, are the members of the tribunal also experiencing this difficulty?
No, it was better now, but of course, the court reporter
Absolutely.
needs to be able to
Takes
produce a
precedence.
transcript.
Yes. So I'm going to restate that the last submission I made, and please, Dawn, if there's any other problem, feel free to interrupt.
Thank you, Council.
So because multiple tribunals have rejected the immediate and direct effects requirement, it's really inconceivable that the USMCA drafters would have incorporated that principle into the legacy clause. But even if, let's assume that they did, even if the immediate and direct effects requirement is valid, that wouldn't change anything. Because the only date on which you can assess the immediate and direct effect of the measures is the date of the measures. Here, the immediate and direct effect of Canada's measures can only be on WCC and its investment. That's true as of the date of the measures, and that's true as of July 1, 2020. Now, this morning, Canada seemed to drop this argument from its presentation, despite the tribunal's express requests that the parties address the inexistence requirement. Canada seemed to scale back its arguments to say that the only thing that needs to be established, or that in addition to that the USMCA legacy provision requires the acquisition between 1994 and the date of entry into force of USMCA, and simply that something exists on July 1, 2020. But what Canada didn't do is explain what is meant by inexistence. How are those terms defined? And how can you avoid incorporating the NAFTA terms that are expressly incorporated immediately after that provision into that definition? Now, with all due respect, as a NAFTA contracting party, Canada knew what the NAFTA said, or what the USMCA meant when it wrote its briefs. Canada cannot simply change its position at the final hour to suit its position in this arbitration, and the tribunal should adopt Canada's initial position that accords with claimant's interpretation, but that adds an additional Article 1101 requirement for an immediate direct effect. Now, Canada's argument, both its old argument and its new one, also can't be squared with the legacy clause, which is to protect against prior acts. Canada does not explain how the USMCA legacy protection can provide adequate protection if it doesn't cover those investors whose investments were lost at the hands of the state. Only WCC provides a clear explanation of what is meant by inexistence on July 1, 2020, that can be squared with the relevant treaty terms, that is backed by official documents, and that is consistent with the object and purpose of the treaty and investment law altogether. I'll turn to my third point on legacy protection. Even on Canada's reading of legacy protection, WCC had a legacy investment on July 1, 2020 in a form of a claim to money. The NAFTA claim that's at issue in this arbitration is not a theoretical unasserted claim. Before July 1, 2020, WCC had already asserted its NAFTA claim in Westmoreland 1. And that NAFTA claim was underway when the USMCA went into force. So even on Canada's reading of the USMCA, the NAFTA claim was in existence on July 1, 2020. Article 1139 of the NAFTA expressly protects interests arising from the commitment of capital. And this protection extends to claims to money as long as those claims involve the kinds of interests that are generally protected by the NAFTA. So if a claim to money involves an enterprise, then the claim to money is protected. Now, claims to money are a core part of the investment because of the core value, the inherent value of legal rights. So if the enforcement of claims is not protected, then the investment is not protected. So if, for example, Canada can take measures that harm WCC's investment, but then block WCC from pursuing investment protection, then the NAFTA does not provide any protection whatsoever. Many prior tribunals have acknowledged that a claim to money qualifies as an investment, both in the context of the NAFTA and other treaties. The leading NAFTA example is Mondev v. the United States. Mondev filed a NAFTA claim even though its real estate project in the United States had failed by the time the NAFTA went into force. So by the time the NAFTA was available, Mondev had no investment activity whatsoever in the United States. The only thing that Mondev had in the US after the NAFTA went into force was a domestic lawsuit that Mondev eventually lost. Despite this, the tribunal upheld its jurisdiction, finding that Mondev's lawsuit in the United States constituted an investment under the NAFTA. Now, Canada has argued that this case is different because WCC has a NAFTA claim instead of a domestic lawsuit, but the principle is the same. An investor seeks to enforce its legal rights in investment arbitration, just as it would in the domestic litigation. Those rights are equally integral to its investment. WCC has at all times retained the right to the NAFTA claim that it submitted to arbitration in 2018. Canada argued this morning that WCC transferred that claim to WMH in the bankruptcy proceeding. But whether WCC owns the NAFTA claim is a question of US law, since the bankruptcy proceedings took place in the United States, and this has been evaluated by prior tribunals and is briefed in our submissions. WCC in this arbitration submitted uncontested evidence that WCC has maintained the NAFTA claim at all times since it was submitted to arbitration. We submitted evidence from the US Bankruptcy Court. We went back to the court to confirm that WCC has retained the NAFTA claim, and the court found that WCC retains title to the NAFTA claim to the same extent that it did prior to the bankruptcy. WCC also submitted the opinion of a retired US bankruptcy judge, the Honorable Shelley Chapman, and she also concluded that the transfer to WMH was void ab initio. It's as though it never happened, and that's because WMH was not able to pursue any relief on behalf of WCC. Now, Canada does not dispute these conclusions under US law. Canada has not presented a conflicting legal view from any other jurisdiction. And Canada has decided not to call Judge Chapman to testify at this hearing. So the tribunal should accept this evidence as conclusive and should find that WCC today owns its NAFTA claim, which is a claim to money because it arose from its investment in Canada. Because WCC still has an unresolved NAFTA claim when the USMCA went into force, WCC had an investment that remained in existence on July 1, 2020, even on Canada's very narrow reading of that provision. Now, Before I leave the USMCA and recognizing that Mr. Rubenstein will address estoppel, I want to remind the tribunal that the only reason we're here today addressing USMCA is because of Canada's abuse of rights. WCC asserted a NAFTA claim while the NAFTA was in force, and it intended to pursue that NAFTA claim until the end. If it weren't for Canada's tactics, WCC's claim would have been adjudicated under the NAFTA without any reference to the USMCA. Thank you. Oh.
Canada's remaining objections are focused on the requirements of the NAFTA. Specifically, Canada asserts 4 objections, the first of which is that WCC's claim is time barred under NAFTA's limitations period in Articles 1116 and 1117. For the reasons that I will explain, Canada's limitations defense is meritless and should be rejected, since the limitations period was told when WCC filed its claim in 2018 until the Westmoreland 1 Tribunal issued its award in January 2022. The analysis is straightforward. As I mentioned, WCC filed its NAFTA claim on November 19, 2018, just under 2 years after the NAFTA limitations period began to run. WCC then unsuccessfully sought to assign its NAFTA claim to WMH as part of the bankruptcy in order for WMH to continue pursuing the claim. After the Westmoreland 1 Tribunal held that WMH could not pursue the claim because only WCC could bring it, WCC then promptly approached the bankruptcy court to confirm that it still had the ownership and title to that claim. And as soon as the court gave its approval on that basis, WCC promptly re-notified its claim and then resubmitted or refiled its claim in October of 2022, less than 1 year after the tribunal issued its award in Westmoreland 1. If the limitations period was told, as WCC claims, it is undisputed that the claim is timely. Canada therefore focuses its efforts on trying to avoid tolling on multiple grounds, every one of which fails for the reasons that I will explain. Starting with the language of the NAFTA itself, it is true that the NAFTA does not address tolling in the text of the treaty itself. And that's not surprising, since treaty limitations provisions commonly do not address what happens after a claim is asserted. For instance, the Peru-US Free Trade Agreement that was addressed in RENCO likewise did not mention tolling in the body of the treaty. However, there are specific provisions in both the NAFTA and the Vienna Convention that serve to incorporate the tolling principle by reference as a principle of international law. Specifically, Article 1131 of the NAFTA provides that in resolving a dispute pursuant to the NAFTA, the tribunal, quote, shall decide the issues in dispute in accordance with this agreement and applicable rules of international law. The incorporation of applicable rules of international law also is consistent with Article 31(3)(c) of the Vienna Convention, which also provides that any relevant rules of international law applicable in the relations between the parties shall be taken into account. In this case, the tolling principle is incorporated into the NAFTA as a well-accepted principle of international law, as I will now discuss. In our submissions, we've cited more than a century of cases recognizing that limitations periods are tolled under international law once a claim is notified to the respondent. The Williams and Gentini cases that we've listed here are just a couple of examples. Based on the very same authorities that we have cited, the tribunal in RENCO 2 held that under international law, the presentation of a claim to a competent authority within the proper time will interrupt the running of prescription. Canada has not addressed this holding in RENCO, including in its presentation this morning. nor have the United States or Mexico addressed this holding in Renco in their non-disputing party submissions. Instead, Canada cites authorities that deal with the entirely separate question of when the limitations period begins to run, which is not in dispute here, since WCC asserted its claim in 2018 within 3 years of the limitations period when it began to run. Now, applying these authorities that we've cited, the Renco II tribunal based its holding on the fact that tolling is, quote, a general principle of law recognized by civilized nations, close quote. Again, Canada and the non-disputing parties do not address this holding in Renco II, that the tolling principle is a well-established principle of international law. Nor do they challenge in their written submissions the fact that tolling is a well-accepted principle under the domestic laws of the NAFTA parties. Based on its finding that tolling is a general principle of law recognized by civilized nations, the Renco II tribunal held that the tolling principle was incorporated by reference into the Peru-US Free Trade Agreement, and that therefore the filing of a notice of arbitration in Renco I suspended the limitations period, even though Renco had submitted a defective waiver with that claim. In addition to holding that tolling is a well-established principle of customary international law, the tribunal in Renco II also explained that application of tolling is necessary in order to allow claimants to cure jurisdictional defects so that they can then resubmit a corrected claim and therefore provide an effective dispute resolution mechanism for the consideration of such claims on the merits. As Renco II points out, this conclusion is even more apparent under the NAFTA because Article 1102(1)(e) of the NAFTA provides that one of the essential purposes of Chapter 11 is to provide an effective dispute resolution mechanism. And as a result, well, in any event, I think it's worth pointing out that Renco has been a centerpiece of our case on limitations since the beginning of this case. Yet Canada still has not addressed Renco's tolling analysis or holding, much less show that Renco was wrongly decided. Now, in Renco, the tribunal in Renco II applied tolling to permit the cure of a procedural defect, in that case, a defective waiver letter, so that the claim could be heard on the merits. Likewise here, WCC's resubmission cures the procedural defect found by the tribunal in Westmoreland I. As the tribunal held in Waste Management II, preventing a claim from being heard on the merits due to a procedural defect is an outcome that, quote, should be avoided, close quote. And that is especially true, whereas in Renco and this case, the claimant has waived all other forms of recourse. Without tolling, it would be difficult and in some cases impossible for claimants to cure procedural defects and then resubmit their claims to be heard on the merits without tolling. As we all know, jurisdictional objections in treaty arbitrations can take years to adjudicate. As the tribunal recognized in Renco, tolling is therefore essential in order to enable the cure and the hearing of claims so that they may be properly heard on the merits. It's also worth noting that the holding in Renco II on tolling is consistent with the NAFTA Tribunal's decision in Feldman versus Mexico. Feldman acknowledged that while the NAFTA limitations period was strict and therefore would not extend the time period in which the claim can be initially asserted, the tribunal recognized that the filing of a claim and the acknowledgement of a claim would probably interrupt the running of the period of limitation. While Canada and Mexico both discussed Feldman, they do not address this central language in the Feldman Award. Applying the Feldman test, the limitations period here was interrupted on November 19, 2018, when WCC served its notice of arbitration on Canada. We also know that Canada acknowledged WCC's claim as far back as 2019 by working with WCC to form the arbitral tribunal based on the notice of arbitration that WCC had filed in 2018. In its reply, Canada agrees with WCC that the purpose of the NAFTA limitations period is to provide predictability and to ensure the available of reliable evidence. Those objectives were met here when WCC filed its claim in 2018, and then by the continuous prosecution of that claim by both WCC and WMH. To this day, Canada has not pointed to any unfair prejudice that would result from the resubmission of WCC's claim and the hearing of that claim on the merits. Since 2018, Canada has been on continuous notice of the need to defend itself. Canada therefore resorts to arguing that, quote, its ability or not to preserve evidence cannot override, close quote, the 3-year limitations period in the NAFTA. But that misses the point. The lack of any discernible prejudice shows that Canada's limitations defense is not meant to vindicate any legitimate right that it may have. Rather, Canada is simply seeking to escape WCC's claim without having to defend it on the merits. As I mentioned earlier, Canada articulates a series of justifications as to why the tribunal should not apply the tolling principle in this case. Canada first tries to avoid tolling on the basis that WCC had withdrawn its claim. But to argue that WCC withdrew its claim is misleading and takes that withdrawal out of context. The correspondence between the parties makes clear that WCC's claim was not being abandoned, but rather was being handed off. It was being assigned to WMH so that WMH could continue asserting that claim. There is nothing in the record which indicates that WCC meant to abandon its NAFTA claim. Likewise, there's the withdrawal of the notice of arbitration had no preclusive effect because the original claim, the notice of arbitration filed in 2018, was not submitted for consideration by a tribunal, and there was no resulting dismissal of WCC's claim. The withdrawal was without prejudice, as explained in the witness statement submitted by Mr. Stein. In fact, Canada effectively acknowledged this in Westmoreland 1 when it said that it was still open for WCC to continue its claim. Canada never told the tribunal in Westmoreland 1 that WCC's withdrawal somehow foreclosed it from reasserting that claim. So this is not a case in which an investor has abandoned their claims only to resurrect that claim later. WCC is merely pursuing the claim that it originally brought in 2018. Canada next argues that tolling should not be applied because the claims pursued by WCC and WMH are different. But in fact, a red line of the notices of arbitration submitted by WCC in 2018 and by WMH in 2019 prove that the claims are identical. The transmittal email that was used to submit the amended notice of arbitration stated there are no changes to the substance of the claim. In fact, Canada concedes in its submissions, quote, the allegations of breach and damage and the description of the factual circumstances leading to them in the WMH NOA were nearly identical to those alleged in WCC's 2018 notice of arbitration. To respond to the tribunal's second question as to whether the claims are identical and what is the effect of that determination, WC's submission is that the 2018 and 2019 claims are identical. All that changed was the identity of the claimant. The same challenge measures, the same facts, the same treaty breaches, and the same relief sought. Now, the 2022 notice of arbitration also is substantively identical because it includes the same challenge measures, the same facts, and the same claims, along with the inclusion of an expropriation claim, as Canada pointed out in its submission this morning. However, the expropriation claim that is asserted is based on the same measures and facts that were alleged back in 2018. The expropriation claim is based on the fact that the measures adopted by Canada, again, the original measures alleged in 2018, destroyed the value of WCC's investment due to the climate leadership plan that substantially accelerated the coal transition, because the coal that was produced at the mines in question could not be transported or sold in other markets, and because WCC was denied any compensation for the destruction of its investment. Again, those allegations were contained in each of the notices of arbitration. The only additional measure that was mentioned in the 2022 notice of arbitration is the federal fuel charge that went into effect in 2020. However, as was pointed out this morning, WCC has withdrawn the challenge to that measure. And as a result, the measures challenged in all three notices of arbitration are identical. In its reply, Canada argued that the 2022 claim also should be treated as different because the 2022 notice of arbitration is governed by the 2013 UNCT rules and not the 1976 rules that were used to assert the original claim in 2018. But that is simply wrong. I mean, for several reasons. First, this arbitration, the 2022 notice of arbitration, was filed under the 1976 UNCT rules. Following the submission of that notice of arbitration, Canada proposed the application of later UNCT rules. WCC, in our comments on the draft of Procedural Order 1, stated that we would agree to the use of later versions of the UNCT rules, subject to the reservation